Thank you, Judge. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-5288, John R. Adams, the Honorable Appellant versus Judicial Council of the Sixth Circuit and Committee on Judicial Conduct and Disability of the Judicial Conference of the United States. Mr. Orphanides for the appellant, Mr. Soter for the appellees.
Good morning, counsel. Before we begin today, I just want to note that today is Judge Jackson's first argument sitting as a new member of this court. And on behalf of the court, I want to extend to her a very warm welcome as she joins us in pursuit of our common calling.
Thank you very much. I'm honored to be here.
Mr. Orphanides, please proceed when you're ready.
Yes, thank you very much. Paul Orphanides on behalf of Judge John R. Adams. First of all, I would like to thank the court for its time and efforts on Judge Adams' behalf. He has sat by designation as a member of the Sixth Circuit, so he knows what goes into an appeal, and I know he appreciates your efforts very much. I'd like to begin by talking about the misconduct finding, because I think that most clearly demonstrates that this case is not moot. There are two very much interrelated components of what we are claiming is direct government action that injured Judge Adams and makes the case not moot. The misconduct finding, it's the misconduct finding that he committed conduct prejudicial to the expeditious and administration of the courts. In our view, the McBride case addresses that. I mean, that is exactly the reason why the court in McBride found that case, that Judge McBride's case was not moot, because there was a determination that he too had committed conduct prejudicial to the effective and expeditious administration of the business of the courts. So this really is no different. In fact, we think this is probably more egregious, because the misconduct finding here, as interrelated with the psychiatric examination order, went to the core of Judge Adams' ability to serve, his mental competence. He's been on the bench for 18 years, the only judge in the 232-year history of the federal judiciary to have been found guilty of misconduct for declining, for objecting in good faith to undergoing the psychiatric examination. Only the second judge to our knowledge who has ever been publicly ordered to undergo such an examination.
So can I ask you a question about the misconduct part of it and how you're conceptualizing the relationship between what you're terming the misconduct part and the examination part?
Yes, sure.
One arguable distinction between this case and McBride is that in this case, the misconduct is a direct byproduct of the examination, because the misconduct is declining to show up for to submit to the examination. Whereas in McBride, you didn't have that kind of relationship between the two aspects of it, the 2 and 1 year time periods and the misconduct. And so I just want to get your reaction to that potential distinction between the two, and why you think that doesn't mean that this case could turn out differently on the misconduct part of it, given that here, if we assume, and I know you'd reject this assumption, but let's just assume it for purposes of argument, that the examination part of it was rendered moot by the council's determination that that requirement would no longer be in effect. And then you have a misconduct, which you're arguing is distinct, but the misconduct is entirely bound up with as a byproduct of the examination part of it that's now no longer in effect?
I think really there's 3 steps. First, there was the demand by the special committee that he undergo the psychiatric examination. And when he did not, that was when he objected, that was what ended up with the misconduct finding. Now, one could almost look as a remedy or as a sanction for the misconduct finding. He was then ordered by the Judicial Council and affirmed by the review committee to undergo the psychiatric examination. So there are 3 components of it. But I don't see that as any different between the misconduct finding in McBride and the sanction in McBride, which was the suspensions. The suspensions there had obviously lapsed, but there wasn't the same interconnectedness between the misconduct finding and, for lack of a better word, the penalty in McBride. But, I think all of the court's cases that deal with direct government action, this is probably I would say this is the most egregious, the most harmful to a judge's reputation. I mean, we have I think the first case was probably Sullivan. That was the attorney that the district court, this district court's bar committee had determined committed misconduct.
Counsel, can I just ask you about that assertion that this is so harmful to the reputation? I mean, isn't this just a recognition that Judge Adams refused to submit to the examination? What reputational harm is there when he freely admits that?
It was a finding of misconduct. I mean, it was not just an acknowledgement that he declined to go. They found he committed misconduct, prejudicial to the effective and expeditious administration of the business of the courts. I mean,
Chief Judge Srinivasan, but I guess I didn't really understand your answer to Chief Judge Srinivasan's question about the fact that finding of misconduct concerned the examination order, which they now say he no longer has to do. So why isn't their withdrawal of the examination order sufficient to terminate any reputational harm that flowed from his refusal to do it?
Because just like in McBride, Judge Adams was found to have committed misconduct. I mean, there's been no revocation, no withdrawal of the misconduct finding. So, I mean, I think of it as misconduct and sanction in both McBride and Adams. In Judge McBride's case, the sanction was suspensions. When those expired, the court said that component of the challenge of Judge McBride's legal challenge is moot, but because he was found to have committed misconduct, that makes the case not moot. So conceptually, we're splitting the two up between the misconduct finding and then the examination order. The misconduct finding exists. It's still out there on the court's websites. It's documented.
So you're suggesting, again, in response to sort of Chief Judge Srinivasan's framing of this, you're suggesting that it doesn't matter that in McBride, the suspension and the misconduct were two separate, they stemmed from two separate sets of facts. So a parallel scenario would be the McBride person is suspended, and then he refuses to comply with the conditions of that suspension. And so they find him to be in contempt or that he's committed misconduct. That seems to me to be more parallel to what we have here. And that therefore they're intertwined in a way that really wasn't the case in McBride. And you say it doesn't matter.
I say it doesn't matter. And I would look to the Sullivan case. This was the attorney misconduct place where the district court's bar found an attorney had committed misconduct. He appealed that. The bar committee then said, well, there's no injury because there was no sanction. This court said he still suffered an injury because he was found to have committed misconduct. Some of the other cases that we've cited, Fordich, for example, Meek versus Keeney.
I think it seems very persuasive to say that a finding of misconduct that's untethered to something else causes an injury. That seems right. I guess what seems a little more complicated about this case is the finding of misconduct is tethered to something that by hypothesis has been ended, that is no longer in effect. And that wasn't true in Sullivan and it wasn't true in McBride. I'm not necessarily saying that that's a distinction with a difference, but it seems to me that it's at least a distinction that needs to be examined because the underlying matter that gave rise to the misconduct finding here by hypothesis is gone. Now, I know your argument is that you haven't abandoned the examination part of it either. And so in some sense, you're saying that remains an issue too. But that suggests that they stand or fall together. And I guess the question is, if we disagree with you on the examination part and think the examination part falls, then does the notion that they stand or fall together mean that the misconduct part of it falls too? Or is there a way to disaggregate them for these purposes, even though the misconduct finding was entirely predicated on the examination requirement because the misconduct was the failure to abide by the examination requirement?
Well, I think this gets back to we see three steps, right? The original requirement to undergo the examination order, the objection, that was found to be misconduct, the objection. And then there was the examination order. Now, the examination order has been withdrawn. Well, actually, it hasn't been withdrawn. It said was no longer in effect.
Right.
What that means is anyone's guess. But the misconduct finding was never withdrawn. We still have a judge who, 18 years on the bench, well-respected member of the federal judiciary who has been found to have committed misconduct. And that is very harmful to his reputation. And I think I don't see how the fact that the penalty, I don't see how the penalty can be separated or for purposes of McBride can't not be separated from the underlying misconduct finding. I mean, that was exactly the case in McBride. The court found the misconduct finding was existent. It was still out there. It was still injurious to his reputation. I think the court actually looked at it from the other perspective, saying, well, what could we do to remedy the suspensions that would be different from remedying the misconduct order? And, I think it said that it was just an incremental injury. The underlying injury was still the misconduct finding. And that's the case here. What we're saying that makes this case not moot is the underlying injury of the misconduct finding that harms his reputation.
Okay.
Can I just ask, I know the time is elapsed, but is there any way to challenge the misconduct finding without litigating the legality of the examination order? Is that, if you continue, is that what the rest of this case looks like?
The rest of this case looks like constitutional and statutory challenges to the authority of the Judicial Council to order a psychiatric examination. So I don't know. I mean, those were the claims that we had sought to bring. They were 4 counts in our proposed amended complaint.
All right.
What was your evidence of a tangible harm to reputation?
Well, 2 responses. First of all, our reading of the law, the court separates into 2 types of injury. One is injury from direct governmental action. The other is injury from secondary effects. Direct governmental action does not require anything more. That in our instance, that's the misconduct finding. Secondary effects require some sort of concrete, tangible effect. In this instance, we have actually had instances. Judge Adams was subject to a judicial complaint by one of the parties that appeared before him that challenged his competence, his fitness to serve. I mean, that's exactly the type of reputational injury. I mean, it's concrete, it's real, it was filed. We can
trace that back to the misconduct finding.
Well, absolutely. I mean, this is the misconduct finding was based on his good faith objection to undergoing the psychiatric examination.
Right. So that is not the basis from which people objected to his sitting, is it, that he failed to respond to this request for an evaluation? Again,
I think in this particular case, unlike in McBride, the two components are so intertwined that it's difficult to separate them out. I don't think that makes the misconduct finding not moot, but I do think it demonstrates that something like the judicial complaint is a concrete, tangible secondary effect. If the court needs to even get to that secondary effect analysis, we don't think it needs to, because we think there's direct government action that has caused the injury.
Can I just get one point of clarification following up on the question that Judge Jackson just asked you? So they're intertwined, as you are suggesting. And is there any argument that you're making in challenging the misconduct finding that's different from an argument that you make that challenges the examination requirement? In other words, is there any basis on which if this were to go forward, a court could conclude that you win in challenging the misconduct determination, but the necessary result of that is not that you would also win in challenging the examination requirement? Or are the challenges to those two kind of intertwined in the way that you've?
Again, I think they're intertwined, Your Honor. I mean, it's just because of the nature of the examination order and the misconduct finding that it makes it so different from McBride that I don't know how you could separate them out.
Okay.
Which I think bears on why neither of them is moot, as opposed to why both of them are moot.
Right.
So you would not be making any different argument with respect to one or the other?
You mean an underlying argument as to why one was legal or one was not legal?
Right.
Well, whatever your challenge is, yes. Was you have any distinct challenge to the one that does not apply to the other?
I think the review committee acknowledged that to order someone to undergo a federal judge to undergo a psychiatric examination was a question of first impression. And to find that constituted misconduct, I mean, to me, I almost compare it to was this a good faith objection sort of analysis? So one could make that sort of argument about the misconduct finding that you wouldn't make about the actual order to undergo the psychiatric examination.
But is that an argument that you've been making? Is that in the complaint?
I think it is. I believe it is.
Okay. But you can't point to a particular part right now offhand. I mean, you can look at it for purpose of rebuttal. That's fine.
Yeah, I don't know. I mean, I'll look at it for purposes of rebuttal.
Okay, that's fine. Let me make sure my colleagues don't have additional questions for you at this time.
Yeah.
Okay, thank you, Mr. Orphanides. We'll hear from Mr. Soter.
Good.
Thank you very much, Your Honor. May it please the court, Kevin Soter from the Department of Justice for the Judicial Council and the Review Committee. I'd like to focus today on why this case is very different from any of the cases in which a claim of reputational harm has saved the case from mootness. As the recent colloquy was pointing out, there is no meaningful difference here between the challenge to what the plaintiff tries to pull out as the misconduct finding and the challenge to this very clearly moot examination order that is no longer in effect, hasn't been in effect for more than 2 years now, and does not require any future action or have any reasonable expectation of future action from the plaintiff. And there has never been any case in which a court has allowed an action to proceed where the request would be for a declaratory judgment opining directly on the merits of a plainly moot issue based solely on an allegation of reputational harm. There are a few features.
Why the reputational harm? You're not saying that the reputational harm isn't real, are you? Because it does seem like a real thing for a judge to be found to have committed misconduct.
Correct, Your Honor. We're not at all saying that the reputational harm is not real, but that it is not sufficient to meet the requirements of Article 3 for several reasons. One of which is that if you look at—
Before you go on, you just also said there's no case that's similar. Is that because you're reading Fudge to be concerning only bill of attainder as opposed to declaratory judgment? Are you making some sort of remedy distinction?
I don't think that's the most important distinction from Fudge, Your Honor. I think the overall theme of these cases is that context matters a huge amount. And the context for the challenge in this case includes something that's just absent from any other case with a live injury, which is the withdrawal of the order that allegedly causes the reputational injury. The claim of reputational harm here is a cloud over the judge's fitness to serve in office that came from that underlying examination order that he's arguing is inextricably intertwined with this misconduct finding. And any reputational harm that flows from that was meaningfully vitiated when the Judicial Council publicly announced in 2018 and 2019, and its orders on those issues are at JA 104 and 106, that the examination order was no longer necessary going forward based on factual changes.
Wouldn't he be, that makes it sound like that there's no way in which the judge would be better off if there were a subsequent statement that says something like, look, we've already decided that the examination requirement is no longer in effect. And because it's no longer in effect, there's no misconduct based on something that's no longer in effect. So that's not any longer on the books either.
So of course, there are ways in which any injury that had been originally lingering might have been vitiated further. But our point here is that there's just not enough left at this point to this case to overcome the rule that the lingering effect of an otherwise moot action doesn't save a case from mootness. So
you think there is, your argument is not that it was necessarily the case that when the examination requirement was deemed to be no longer in effect, that the spillover harm from the misconduct just disappeared. Your argument is that there may still be some spillover harm from the misconduct. It's just not enough.
I think, yes, all we need, of course, is that there is not enough to support Article 3 jurisdiction. The point is, of course, there can be challenges in drawing this line. And I think this court's cases illustrate that some cases will fall on one side of the line and some will fall on the other. And the reason is that in the course of issuing orders, making decisions, governments and private parties all the time are going to make findings. They're going to describe things in the course of making an order or a decision. And those descriptions and those things that could just be couched as factual findings can't form the basis for an independent challenge once the decision or the order that's made is later withdrawn and mooted.
Can I ask you this hypothetical? So suppose that what happened is there's an examination requirement that's imposed and the judge declines to abide by it. And then what the council says is, we've imposed an examination requirement that we think is on perfectly sound footing. The judge has declined to comply with it. It's not necessarily enough to deem him to have engaged in misconduct that he declined to comply with it. But we think that his declining to comply with it was in especially bad faith, given the significance of the inquiry that we're undertaking. And because of that, we're finding that he engaged in misconduct by declining to abide by the examination requirement. And then later on, the same thing happens here. The examination requirement is eliminated going forward. Would you still say that the misconduct determination is necessarily an adjunct to the examination requirement that's now moot, and therefore that goes away too, even though here the rationale would have been not every failure to abide by an examination requirement results in misconduct, but this one does because of the nature of the proceeding?
I think that probably still wouldn't cross the line. Of course, there are, for the reasons that Your Honor states, there are reasons why you could think maybe that comes a little bit closer to the line in this case. But the important features would remain similar, which is that there is still something later that vitiates the reputational effect from the challenged order. There is still another feature of this is that the claim of reputational harm has to be traceable to the specific order that's actually being challenged. And here, there were these proceedings that were ongoing about misconduct related to behavior toward a magistrate judge, a reprimand for that, none of which are challenged in this case, and all of which will remain a matter of public record regardless of success in this case.
So at that point, let me ask you then, are you essentially arguing now that this case is covered by the incremental harm analysis in McBride?
I believe it's covered by several pieces of McBride at once. Of course, the most direct application is to compare it to the expired sanctions that didn't save that case. And it's important to remember the challenges in McBride were to specific sanctions that were imposed against the judge. Each of those would have been tied in some way to something like a set of findings, like the 159-page report that was found to be stigmatizing enough to confer ongoing jurisdiction for the reprimand, which is a specific sanction available under the Act. But unlike Judge McBride, Judge Adams was not issued a specific sanction for refusing to comply with the evaluation. These were ongoing proceedings. There was an ongoing investigation into whether a mental health disability was present.
But I ask you, you seem to be resisting the conclusion that we have more than just a statement that he didn't comply with the examination order. We have a separate finding by the council that not doing that constitutes professional misconduct. So it's not just the report says he didn't do it, and then we go on to say, so we're ordering him to do an examination. In that circumstance, I understand there are lots of findings that lead up to what you seem to think is the main show, which is the examination order. But along the way here, they also made a separate, it seemingly inherently stigmatizing finding about what it meant that he didn't comply with the examination order. And I don't understand why that doesn't give him a basis when they don't retract that in addition to the examination order, why that isn't enough in light of McBride and Fudge and Sullivan and other cases in which we have considered that to be sufficient.
So two responses to that. One, on the facts of this and how that misconduct finding fits in the context of this ongoing investigation. When you look at when the misconduct finding was made, if you look a couple of pages past that, I think it's at the very end of the Judicial Council's report, on page JA 60, you can see that it was being considered misconduct in order to support possible future actions. There was no sanction connected to this misconduct finding, like the sanction of publicly reprimanding the judge for the behavior toward the magistrate judge. And similarly, if you look at what the review committee said at the end of its order, I think this is at JA 99, they're also talking about possible future actions for the misconduct that had been found. So this is very unlike the public reprimand in McBride that could be challenged on its own, and much more like something that we're talking about the order that's expired and a potential challenge to that.
But why isn't that just Sullivan? Isn't Sullivan the one where the attorney was found to have committed misconduct of some sort, but they didn't impose a sanction? So fine, they didn't impose a sanction. Isn't that exactly what happened in that case?
In that case, though, the finding was reached at the culmination of the proceedings. There was no ongoing investigation. There was a determination that the attorney had committed misconduct that was subject to direct review on appeal. And there wasn't anything later that happened that vitiated any reputational harm that flowed from that. I see my time has expired. May I continue to answer?
Yeah.
So I think I also mentioned there was the legal point also in reconciling these cases. The important thing to keep in mind is context matters a huge amount in how these cases come out. And the cases that stand for the proposition that you actually have to prove up your claim of reputational harm are perhaps best illustrated by this court's decision in Gould, in which former detainees from Guantanamo claimed that their label of being enemy combatants continued to cause ongoing stigma, ongoing harm, and this court readily dispensed with the argument that stigma alone could be enough.
But isn't Gould really more about sort of the habeas analysis and collateral consequences? It seemed to be a little bit of an outlier given the other kinds of reputational harm cases that we're talking about here.
I don't think it's an outlier at all. It relies on core principles of Article 3 jurisdiction. It relies on Spencer versus Kemna, which went through a detailed analysis of why presuming collateral consequences from anything, including potentially a criminal conviction, as discussed in footnote 8 of Spencer, isn't enough to confer ongoing jurisdiction. And I'd like to emphasize that when pressed—
Wasn't it terribly relevant that the complainant was no longer subject to U.S. jurisdiction?
I didn't read that to be a dispositive piece of the court's analysis. I read the analysis to be discussing that the case had become moot by the release from custody, just like this case has become moot by the ending of the examination order. And when there's the lingering effect of an otherwise moot action, the case doesn't survive. That rule was also applied in this court's case of Anderson from 2015. Just all of these numerous cases in which that rule controls, including, of course, the moot portion of McBride, where we're talking about you have these different sanctions, all of which would have been premised on some findings, but the ones that had expired were moot.
But can I ask you, it seems to me to matter, and maybe it doesn't. This is where you come in to tell me I'm wrong. It seems to me to matter that in Anderson and potentially Gould, we're not talking about a public document that's on a website labeling these people as, incapable of writing as a journalist, incapable of writing with military combat people, or Gould, he may have been labeled an enemy combatant, but who really knew that? our current situation is a misconduct finding that even if it's a part of an investigation, even if it's in progress, it is publicly available on the court's website. And therefore, isn't it distinct from the kinds of acts that we say were mooted by the release of the prisoner or by the change in the fundamental nature of the embed program?
I don't think it's distinct for those reasons. I don't think there was any suggestion in those cases that the claim of reputational harm failed for not being publicly disseminated widely enough. But even moving past that and looking at, for example, the moot portion of McBride, I think the takeaway from McBride is if Judge McBride had only challenged his one-year suspension from being allowed to sit on any cases, his challenge would have been completely moot. There would have been no basis to reach any of his challenges. And that's why footnote 5 of the opinion doesn't reach the merits of his claim that that's unconstitutional. And so, but similarly, if he had been sanctioned in that way, the sanction would have had to be supported by findings that under the statute would presumptively have to be public. That's the statute currently at 28 USC 360B says that when you have one of these sanctions, including a suspension from cases like was done in McBride, you have to explain the basis for that and make that publicly available absent good cause otherwise.
So on the facts on McBride, for example, you've got the 1 year period where the judge was not supposed to take on new cases. Suppose that what happens is then the judge decides to undertake some actions that attempt to take on new cases. And sends out some emails to the clerk's office and says, I know there's an order in effect, but that don't pay any attention to that. I'm in the courtroom. I'm ready to hear cases. Please start assigning me cases. And then that becomes known. And then there's a misconduct determination based on the idea that the judge is undertaking actions in breach of the requirement that the prohibition against taking on new cases. If the prohibition goes away, your argument would say that the misconduct, the actions that were undertaken in an effort to circumvent the imposition of the order that you're not taking on any new cases also goes away?
That does sound relatively analogous. I would say that the context for these things always matters. So if there is nothing in the later proceedings that could be seen to vitiate the effect of the misconduct finding, you might draw a distinction based on the difference between the mere expiration of a sanction and the mere expiration of, I guess it would be the sanction in that case, and the withdrawal of one, which is a point that I think this court's decision in Penthouse illustrates well, that in that case, the government letters that were the claimed source of reputational injury were affirmatively withdrawn. And I think that's a better analog to what happened here than mere expiration of a sanction that has a time limit on it. When the Judicial Council publicly announced that there was no longer an ongoing concern that required an evaluation to take place.
Can I ask one last? Oh, go ahead.
I don't understand why that distinction matters from the standpoint of mootness when you're talking about the ability of the person to challenge that separate finding. Why does it matter whether the event is a withdrawal or an expiration of the sanction?
I think it goes largely to redressability, Your Honor. What we're talking about here at the end of the day is a declaratory judgment that would require opining on the merits of this moot issue. And the question is whether there would be any meaningful redress that could be provided by declaring that the misconduct finding and necessarily intertwined evaluation order were unlawfully issued. And when you have a situation where an order has already been withdrawn, the point that's made in Penthouse and that's quoted in Fortich is you can ask, what more is there to gain by the order that's being sought? And when you look at that incremental effect of the order, particularly given the background here of the many things that will not be changed that could affect the judge's reputation, there just isn't enough left to this case. And I think another point that illustrates that well is when you consider the specific consequences that the plaintiff attempts to point to. And you look at, for example, the speculation about what's motivating the behavior of Sixth Circuit judges who are sitting on appeals and considering whether they meet the standards to remand to different district court judges. That level of speculation has just never supported a claim of ongoing harm sufficient to save a case from mootness.
But it seems like if I could just encapsulate your argument, several times you refer to vitiating the effect, which to me sounds like the effect is gone. But then other times you've talked about lingering effect, which to me makes it seem like there's still a lingering effect. And so the way that you could bring those together is to say, even if there is an incremental effect from the continued existence of the misconduct language, that's just not legally cognizable. But that's different from saying it actually vitiated the effect, because what could you possibly be complaining about? Because the thing that the judge was alleged to have infringed is no longer in effect anyway. So as a practical matter, there's nothing to be complaining about. Those seem to be different.
I view those as similar, but I think that the only conclusion the court needs to reach is that there is no longer enough effect so that meaningful redress could be available through the specific relief that's been requested, which is a declaratory judgment opining on the legality of the examination order. As the earlier colloquy was canvassing, there isn't anything that I can find, and certainly no argument I've seen made, that there is a distinction between a challenge to the misconduct finding and a challenge to the examination order. When you look at the counts of the proposed amended complaint at JA 124 to 126, nothing there about some sort of distinct legal claim that could be based on one without being based on the other. And at the end of the day,
how is it then that Judge Adams gets to litigate his concern that what happened here was that he was being charged with contempt under circumstances in which he shouldn't have been? And I know that that means we have to assess the extent to which the original order was valid. That's always been his claim. It wasn't, but that's just because he says, I'm not in contempt because the original order was invalid, which he distinguishes in some sense from a full frontal challenge on the original order, which he can't do anymore because that's moot. You've now said the two are combined. He admits there's no daylight in terms of the actual litigating position, but there's still this concern that he wants to be able to litigate the contempt order. And I don't hear you giving him any opportunity to do that. He can only do that while the underlying thing is live. Is that what you're saying?
that sounds like an encapsulation of it. Yes, I mean, of course, just wanting to litigate something is not enough reason to get you into federal court. Psychic injury isn't enough. And as Steele Co. points out, every plaintiff who files a suit would desire a ruling on it, but that doesn't mean that there is enough for Article III jurisdiction. And here, there just isn't enough left to this case. And that's why the case is about lingering effects of an otherwise moot action control. It's like the lingering effects that were at issue in the moot portions of McBride, and it's like the lingering effects that were left in this court's other cases. We're left with a case where there was this challenge to an examination order that remains the focus of the challenge, but all we're left with is the tail trying to wag the dog of this case.
So I want to ask a question that addressed to Mr. Orphanides when he comes back, but to you right now. If the case were to go to trial, what would you expect Judge Adams to present? What's the best he could present that would still be insufficient, in your view, for meaningful redress?
So I'd like to clarify, this case should not go to trial. There were threshold issues that were raised, aside from mootness, that have not been resolved by the district court. But the only request I'm seeing in the proposed amended complaint, which was the specific proposal that was made to try to get around the mootness of this case, is for a declaratory judgment. And of course, the court would have ample discretion, for the reasons that we discussed at the end of our brief, to deny that form of relief at the end of the day, even in the very unlikely event that this case were to survive the viable threshold defenses and were to prevail on the merits.
Well, okay, the request would be for a declaratory judgment, but what would you say to the trial judge the plaintiff has to show and cannot show, in your view?
On the merits of that, we would say that the plaintiff has to show that the four challenges in his proposed amended complaint survive these threshold challenges and are correct interpretations of the law on the merits, which would include, so his claims are facial constitutional challenges under void for vagueness doctrine, and he also has an ultra vires challenge to the examination order and an as-applied due process challenge to the process in which the proceedings
At
went.
some point, we get through that conceivably, to what facts would he have to prove up, which he cannot do in your view?
So I think as far as the fact, I mean, the only challenges that would even potentially get to the merits are these facial constitutional challenges, for which I'm not sure the facts would matter very much. He'd be talking about, does the language of the statute give enough notice that the steps that were taken in this investigation were appropriate? And the reason why that challenge fails at the threshold on a 12b6 basis is that he's not talking about anything that governs conduct to which the void for vagueness doctrine even applies. And even if it did, the statute is not vague.
I'm sorry to keep going on so long, Chief, but can I ask you about why it is that the council didn't just also rescind this aspect of their investigation? They got rid of the examination order, but it seems very almost calculated in a way to remain standing behind and to leave in place this finding that he was held in contempt. And in my own mind, as I went through everything, I wondered whether that standing alone was sort of doing work from the standpoint of the council, that we want people to know that when we order them to do things, they have to do it. And if not, we're going to hold them in professional misconduct or say that that's the case. And it's going to be on the website, so that even now, though we say Judge Adams doesn't have to do this examination anymore, there's still a benefit to us as the council for leaving that in place. Am I totally off base? Was this just a clerical error that they meant to get rid of the whole thing and they left that in?
So I can't speculate about what was motivating them. I don't think there's anything in the record about that. But I also don't believe that there's anything reflecting that Judge Adams ever asked for this misconduct finding to be scrubbed from the books in some way. That's a request that he made in this litigation after the only order with any operative effect was declared to no longer be in effect. So I think that all what we're left with at this point in the case is we have this misconduct finding that the plaintiff is trying to home in on to say it saves the case, but it's just not enough. And it was this interim step as part of these ongoing proceedings about possible future actions, including potential future concrete sanctions, like the concrete sanction of a reprimand that was at issue in McBride, or the concrete sanction of case removals, if the misconduct were to continue. But at the time, there was just a specific finding that misconduct had occurred up to that point in the investigation to support potential future actions in the ongoing investigation that never came to pass.
Of course, it'd be really easy to end the case by everybody's estimation if, in response to I take your point that the issue may not have surfaced until the litigation was filed. I understand that point, but it would also be very easy to resolve the case if, once the litigation is filed and everybody's on notice of what's at stake, then the council just issues a subsequent ruling that just says, oh, now I see what's going on. By the way, we're going to rescind the misconduct portion of that too, just to end any debate about it. And then the case would be over by everybody's estimation. That could happen, I suppose.
So I agree. I think our point that would certainly make the mootness analysis even easier. But our point is that what happened is similar to that in enough relevant respects to cross the threshold from jurisdiction to no jurisdiction.
Got it. Thank you. I'll make sure my colleagues don't have further questions for you. And then thank you, Mr. Soter. Mr. Orphanides, we'll give you 2 minutes for rebuttal.
Thank you, Your Honor. From Judge Adams' perspective, and this arose at, we'll call it at the administrative level, back when it was still in front of the special committee and the Judicial Council. We did challenge the authority to find him in misconduct for objecting in good faith to what was a question of first impression. So this is not something new, and for purposes of this litigation, this has been an issue all along. I was asked about, where in the complaint is there this distinction? And I really think it's structural. We have 3 counts that really challenge the authority of a judicial council, a special committee to conduct or to order a psychiatric examination. And then we have the due process challenge. And I think that goes more towards the examination order and the underlying reasons for the examination order. But so it's a bit structurally in the complaint, but they still are. They're distinct issues, and yet they're interrelated issues. And I don't know how else to explain it other than the fact that there is a misconduct finding out there that has not gone away. We have objected to it. We objected when they were contemplating holding him in misconduct for objecting in good faith, and we're now litigating it. Counsel said there needs to be a line. Well, Sullivan, there was no sanction at all. So the line clearly is there a misconduct finding? Traceability. The Fudge case. I think anybody who was in DC I don't know if it was the 80s or the 90s, but remembers, all of the publicity about that case. And, Congress piled on, and yet the court found it could provide meaningful relief to Dr. Fudge if that finding was declared unlawful.
Well,
So,
Dr. Fudge, just as you just said, though, had been maligned, and it was the subject of an extensive press coverage. I can see that. But here, it's quite a different situation, much more inside baseball. So just bear with me and assume that you can get through all of the threshold issues raised by the government. Are there any facts you're going to proffer?
Oh, I think if we were to go to trial, we would show the press coverage of the issue and the negative press coverage that Judge Adams got while this was underway, when he was found to have committed misconduct and subject to the examination order. You
have to have some contemporary consequence to prove up, not something that was published simply because it was published 5 years ago.
Well, that certainly is analogous to the Fudge case, where there was publicity as well. But the question is meaningful relief. Is meaningful relief available by finding that there was no authority to order him to find him in misconduct, to find he had committed misconduct by objecting in good faith?
Can I ask you another version of the sort of incremental harm question, which is, my understanding was that Judge Adams did not challenge the misconduct finding that arose from his having issued the order to show cause in the first place. That there was a finding, I thought, about that wasn't challenged. So there's already in the record and in the public view and in newspapers, presumably, some press coverage of his having done that to begin with, the issuing the order, and having been found to be in misconduct, giving rise to the need for an examination order. So how much more reputational harm is there from this essentially second misconduct filing that arises from his refusal to submit to the examination order?
He absolutely challenged it before the Judicial Council and the review committee. We chose not to challenge it in the litigation. But at the same time, I don't see how that's any different from the misconduct findings in McBride or in Sullivan or in Fudge. There was negative publicity about the underlying, each of those underlying, cases. But still, the court found that they could afford meaningful relief, even if it's just a small, narrow component of it, that was sufficient to keep the case from being moved. So, and we don't see that any different here. I mean, if this court were to find, if the court were ultimately to find that it was, there was no authority to order Judge McBride to undergo a psychiatric examination such that he could not, his objection to undergoing that was not in bad faith, not misconduct, that would provide meaningful relief. The court would be saying that he did not, commit conduct prejudicial to the expeditious and effective administration of the business of the courts. That would be meaningful relief to Judge Adams. And I think that's supported by McBride, Sullivan, Fudge.
Okay. Thank you, counsel. Let me make sure my colleagues don't have additional questions for you.
No.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 20-5126, NYC C.L.A.S.H Inc. et al., appellants versus Marcia L. Fudge, Secretary of Housing and Urban Development in her official capacity, and United States Department of Housing and Urban Development. Mr. Joseph for the appellants, Ms. Powell for the appellates.
Mr. Joseph, please proceed when you're ready.
Good morning, Your Honors. May it please the court, my name's Lawrence Joseph. I'm representing the appellants. I'd like to first touch two related housekeeping issues. One, as I mentioned in a 28J letter, one of the appellants, Mr. Fields, I've lost contact with him. His injuries are no different than anyone else's, so we don't think it affects the Article 3 context of the case. Having just listened to the prior argument about Article 3, I noticed that we didn't brief standing. The court below held that we had it. I just want to assure you that there is an ongoing Article 3 case or controversy. Basically, what's happening here is HUD regulates public housing authorities, PHAs, where my clients are tenants, or in the case of C.L.A.S.H, an interest group that has tenant members and advocates on behalf of tenants. Before this mandate, some PHAs had smoking bans. Some had less onerous ones than HUD's, and then HUD comes along and says you have to have this as a condition of the federal money you receive. So the basis for so now all of the PHAs have adopted smoking bans, but if we were to succeed in withdrawing the HUD mandate, my clients would be free to negotiate with their PHAs to ameliorate them. To ameliorate the smoking bans, or to rescind them entirely. Whereas they can't do that now without HUD's pressure. And there's numerous cases for that kind of injury, which is affecting their article. By the way, these are government entities, the PHAs and HUD, of course. And so it's not only interfering with their contract between landlord and tenant, it's also interfering with their ability to petition government. So I hope there's no question about Article 3 anymore in this conversation, but given the length of Article 3 in the last case, I wanted to flag that. It's at JA 114 would be the place where that standing is established, and that ongoing interest to want to petition the PHAs and that HUD's in the way. So I think we're good on Article 3, other than Mr. Fields, who I don't think matters. I think the recent Supreme Court stay of the CDC's eviction moratorium is a pretty good framework for this case. We filed a 28J on that a few days after it was after the Supreme Court issued it. And essentially there, as here, you've got an old statute that an agency has sort of, an old bottle that the agency has tried to pour new wine into in a way that hasn't happened before. It's not clear that they have that authority, the federal agency. They're working in an area, landlord, tenant, et cetera, where there's a strong federalism presumption that the agency's statute should be read narrowly.
Mr.
And
Joseph,
so,
can I just clarify though, because I was a little confused by your 28J letter, insofar as my understanding is that the Alabama Association case involved an entirely different agency than the one at issue here, and a different statutory scheme. So what is it about this case that you think either informs or governs this court's consideration of whether HUD has the authority to do what it did in this case?
well, it's more of an analogy than a holding. It's a holding, I suppose, on the issues of the federalism component of the landlord-tenant relationship. That's something we've briefed as well, and separately, but it reinforces that. Certainly, it's a different statute. In their favor, that is CDC's favor, they have an emergency that's not at issue in our case. But the point is, you've got a statute that's been around for a long time, and the agency tries to creatively come up with new authority to do something new that they've not done before. And so, but you're right. We're dealing with the Housing Act, not the
Okay,
Public
well,
Health Safety Act.
Can we explore a little bit how new and what you mean by the agency is doing something that it hasn't done before? And the reason why I'm asking is because I looked up the regulations about lease requirements from HUD, and there's like a long list of stuff that HUD routinely requires PHAs to put into their leases. So when you say this is something new, it's not, you're not saying this is something new because HUD has never asked or required PHAs to have certain lease conditions, right?
Certainly, it goes into the lifestyle aspect of this particular decision. They're actually claiming to regulate how you interact with members of your own household. So by analogy, for example, when with regard to pets or lead paint, the Congress has amended the statute to sort of allow them to deal with that. Now, lead paint is more serious than pets. Pets is more like a lifestyle thing, although it certainly has, cats can scratch things. So there are effects, but the point is, before the HUD ventured into those sensitive areas, there was statutory authority. And the same thing happened, again, by analogy, different statute, with cigarettes and the FFDCA, the Food, Drug, and Cosmetic Act. There, something that looked a lot like a regulated commodity, cigarettes, the Supreme Court said, well, no, that's not clear that Congress is going after this kind of, in our statute, in our context, lifestyle.
Yeah, but Mr. Joseph, the lifestyle aspect that you're raising is but one of the two major premises for justifications for the regulation in question. The other has to do with fire safety, with damage to the property. I mean, there's a reason that private landlords all over the country, maybe all over the world, are also prohibiting smoking where they can. Airport authorities and so on, because it causes damage. And when you have tenant turnover, there are extra costs to repairing the apartments. Why isn't that it is a completely separate justification. Why isn't it unimpaired by your lifestyle argument?
Well, if the lifestyle
about that, really, right?
If the lifestyle issue were stricken, then they'd have to reconsider their rule. They didn't consider alternatives like have a deposit or like have fire insurance, or certainly as to the smoking has to be more than 25 feet from the door. If they were just concerned about those issues, they would have smoking facilities closer to the door. But they're focused on the lifestyle thing. I understand.
Why are you saying that? What do you mean by the lifestyle thing? Because I understood the statute to cover health and sanitation, and we're talking about air quality in the building. So are you equating lifestyle with air quality?
I guess
what you mean?
Fair enough. I'm using a shorthand and I shouldn't have. They are trying to regulate lifestyle, meaning the sense of they're trying to discourage smoking, and the so there's the intra-unit exposure that they say they're trying to regulate now, and then there's the inter-unit exposure, which is they quite frankly didn't document that well enough, we think, for a constitutional challenge. So
you perceive them as not telling the truth when they say that the reason why they're regulating this is because they have evidence concerning the secondhand smoke effects, the effects on health and safety, and the fire risks. You think their real reason is just they don't want their tenants to smoke inside to smoke?
There's a pretextual aspect to it, yes. There are, on top of that, if the opposition to smoking were removed, there would be other regulatory alternatives that they didn't consider, and that would make this arbitrary and capricious.
Did you argue that? Did you
Yes.
argue that I understood? I know you argued pretext. Did you argue that if the sole justification were the fire safety and damage prevention, that there was that you, as you just said now, they would have had to consider alternatives that they didn't, and so on?
Yes. We cited the MVMA case on that proposition, cited the
You argued
different
this
things.
before the agency. There was notice and comment by this agency. Did you put that in the record before the?
Oh, I'm sorry. You're asking about the comment period.
Yeah. You can't
We
raise
did-
an exception here you didn't raise with them.
Fair enough. So we argued it below in the district court. We argued it here in this court. We did argue in the comments that that their data were pretextual.
That's different.
Okay. I honestly don't know the answer to your question. I can.
My concern is that I think they have an adequate and independent ground on which to rest the lease requirement, which you have not really touched, and therefore would be sufficient to uphold the requirement.
It's a little challenging, and the difference between a constitutional challenge and an APA challenge, because in a constitutional challenge, if it's a rational basis standard, then under Heller and other cases in that canon, they don't even have to say the reason. They don't even have to get the reason that they're regulating right, if it's as long as you
could make it up.
right. So on that side,
This
on
is
the
a statutory question as far as I'm concerned.
So on the constitutional side, if I've missed your question, I apologize. Let me finish this thought if I could. So on the constitutional side, you can make things up, but on the APA side, it needs to be something that they justified in the record.
Correct. That's where I'm coming.
No, I understand, but there's another facet to that sort of flips those, and that is that on the constitutional side, it's less clear that we're bound by the record.
Yes, I grant you that.
Okay, so with that context, that in constitutional we're at a disadvantage if you can make up a new answer, but we're at an advantage because we can go beyond the record. Maybe I don't understand your question.
Assume with me for the moment that for one thing, that we'll start with the non-constitutional issues, which we ordinarily do, right?
Fair enough.
We don't reach a constitutional if we don't have to. And if your statutory issue, so we need to deal with whether first, do your statutory claims survive? Are they properly presented? And I'm suggesting that a reason that the agency has an independent ground that you have not challenged, and therefore your APA concerns are not well taken. And then we can move on to whether you have any constitutional ground for objection.
I believe so I don't think that anyone has raised your question, which I concede is a good question. But had they raised it, we would have rebutted it. So I'm going to need to do two things if I could. I need to go and look at the comments that may well be there. I don't know. Well,
the red brief certainly suggests that they have an independent ground in their concern with their proprietary interest in the structures, right, and the fire and safety and so on.
Oh, but there, I mean, we did rebut those arguments when they raised them. They raised them for the first time in district court. So
well, it's in the rulemaking document.
And what is the it?
Data about the effects, the costs of having smoke damage to the buildings. They put a dollar figure on it.
I see. So I'm going to have to look and see the extent to which we raised those arguments. I don't believe that's been put to me to respond to in court yet. So I don't know the answer.
So can we do it as a hypothetical here today? So if the agency says, setting aside air quality and secondhand smoke effects and the health risks, totally aside from that, the reason why we are requiring this is because there is a risk of fire to our buildings and smoke damage to our buildings, and we want to make sure that that doesn't happen. So we are requiring PHAs to put in their leases, no tenants can smoke, right? That's the only thing. Are you saying the agency does not have the authority to do that under the statutory provision at issue here?
I think the answer is yes. I mean, if it's pretextual, if there are other things that they could have considered to ameliorate those same things, their failure, they had an agenda here. And
just the failure to consider reasonable alternatives is something you can raise if you suggested them in the rulemaking and they didn't consider them.
I'm pretty sure we suggested a no project alternative.
I understand that, but you're just now saying, deposit damage for damages and so on. This is at 11 in the red brief, the summary of their argument. HUD determined that the prohibition would also reduce deaths, injuries, and property damage caused by smoking-related fires, as well as maintenance costs. Now, as I say, they argue that later on. This is the summary, and they put a dollar figure on it. So, I mean, it seems to me that your APA argument just has to rise or fall on whether you've rebutted that or even raised it, and I don't think you have.
And again, the place where we would have raised it in the comments, not because we've argued against this.
Then you'd have to preserve it in your blue brief, and I don't think it's there. I don't think I mean, I realize you said pretext, but I don't think you said that even if it's not pretext, if it's an independent ground, it's somehow deficient. Am I correct in that? I think that we can tell by looking at the blue brief. And to move things along, I'll start with your summary.
Well,
there. Maybe it's further into the brief, but it's not in the summary.
The point that we tried to rebut this with is that they would have had to consider alternatives that they didn't consider if this fire safety only rationale were raised. And so these are,
if you had proposed them before the agency, yes.
I see. And I don't know if we had, we briefed it, but in both courts, but I mean, I'm not sure if you're saying that the blue brief waived it or that the blue brief failed to preserve that we raised it in the,
if it's
before
not
the agency.
Brief, it's forfeited. If it's not raised before the agency, then it was forfeited earlier.
Well, I think we did raise all this in the blue brief. I can try and pull that up and find where. Or perhaps I could bring that up in rebuttal.
Why don't you do that? Sure. And similarly, if we go to the constitutional issues, of course, the government needs only one valid claim of authority, and their most promising one, I would say, is the spending clause, right? Because the question there would be whether they're making a legitimate, permissible condition on the expenditure in question here, correct?
That's the only basis that they have for.
Right. So they've got the Dole case on the passive restraints and some subsequent as well, but it seems to be well within the range of conditions on expenditures that the government has been upheld in imposing.
Well, that's not the only part of the analysis. It's ambiguous. It's not even clear if it's enforceable. Their enforcement authority only extends to things that are substantial. They're trying to say this is a change in a mere adjustment, but you first have to ask, is it quote substantial unquote under their enforcement authority? If it is, then it's not a mere adjustment. If it's not, then it's not even enforceable, and they should take away the mandatory language. It's coercive in the sense that they not only claim the ability to terminate funding, but that's assuming it's enforceable.
And by the way, let me ask you this, is there anything in the record that shows, or I don't think you've raised it in your briefs, the extent to which PHAs rely upon HUD funding?
We
say they do, but there's no numbers that I could see.
There were, we cited to it in the, essentially what happened is that we didn't address that. We sort of assumed that that these local agencies rely on the money. HUD did not counter on that issue. This case was decided on cross motions for summary judgment. So we would argue that that's an issue that they didn't win on either. This is not a 12B6 motion of that we failed to state a claim. We think it's either coercive or it's not. And so what we did in a post-judgment motion is
it's on you to show that it's coercive. Right, that's just the way that the burdens lie.
Yeah.
Well, for us to get summary judgment, but they got summary judgment, which means that it's not coercive.
Right, but they can get summary judgment by showing that you didn't meet your burden.
Right.
Oh, I would have thought it was that there was an excluded middle there, which is neither side prevailed on the issue of coercion. But in any event, in a post-judgment motion, we submitted evidence. It's judicially noticeable. You can look at judicially noticeable evidence on appeal. We haven't moved separately for judicial notice, but we have pointed you to that from the appendix, in the joint appendix. I can find that site.
Yeah. Let me make sure my colleagues don't have additional questions for you at this time. We'll give you a little bit of time for rebuttal, but if not, then why don't we hear from the government? Thank you, Mr. Joseph. Ms. Powell.
Thank you.
Good morning. May it please the court. Lindsay Powell for the government. The rule that's at issue here is entirely in keeping both with prior standards that HUD itself has promulgated under the same authority to establish standards for safety and habitability in public housing. And it's also in keeping with the actions of other public and private authorities. So this isn't really breaking new ground in the way that's being suggested. Even prior to the rule, there were hundreds of public housing agencies that had implemented similar rules, dozens of municipalities, and this includes prohibiting smoking within individual dwelling units. And then many private landlords do the same. And the reasons for that are made clear in the administrative record here. HUD amply documented the significant risks of smoking in and around buildings. We have the substantial fire risk. At the time the rulemaking record was put together, smoking was the #1 fire risk in these buildings. There's other property damage that ensues. And then of course, the science of secondhand smoke and inter-unit transfer is itself well documented in the rule and prior to that by the Surgeon General. So all three of these provide a substantial basis for the decision here.
I think, Ms. Powell, the problem with secondhand smoke, if there is one, is not that it's not harmful, it's that it's not shown how the degree to which it ever permeates someone else's apartment.
Yes, Your Honor, that is absolutely something that HUD addressed in the rulemaking, and it is borne out by the science here. So it's addressed at length in the NPRM.
It is what was borne out by the science.
That inter-unit transfer does occur and that it causes harm. That is in the rulemaking record here. And there were some comments that superficially contested that, and HUD addressed those in the final rule, again, reiterating both the harms from secondhand smoke itself and the fact of inter-unit transfer, including the demonstrated scientific fact that there's no safe amount of secondhand smoke exposure. So even small amounts transferring between units through hallways, between walls, down air vents, causes harm to other tenants. And HUD standards, if you sort of go back to the regulation, and this is at 24 CFR 966.4F, there are a variety of tenant obligations. So I think sort of one of the intuitions at play here is that HUD, in establishing standards for safety, may be principally regulating the conduct of public housing agencies themselves. And that's not how HUD has historically interpreted or implemented this statute. So at subsection F that I referenced, it's called Tenants Obligations. And there are a number of other requirements for tenants that ensure that other tenants are able to safely enjoy the premises. So for example, tenants are required to dispose of their garbage in a safe and sanitary manner. And so this is no more a lifestyle requirement than that. Tenants must comport themselves in a way that doesn't interfere with the safe enjoyment of other tenants, and not smoking indoors or near the premises in a way that causes the transfer of smoke into other units that creates a risk of fire and property damage is entirely in keeping with those prior exercises of authority by HUD.
Can I just ask you about the scope of HUD's authority as you interpret the statute? Is any level of health risk to individuals in these public housing complexes and structures fair game? Is anything enough to make it sufficiently unsafe that you believe that Congress authorized HUD to regulate it? And I guess what I'm just getting at is, you know, the example, you can imagine a world in which you know, HUD seeks to regulate what parents are feeding their children inside public housing complexes, because we know that certain kinds of junk foods are unsafe. Is that on the table, or does habitable, what is the word, or housing quality standards, like, does that do work to constrain HUD's authority in this context?
So I want to answer generally and then take your specific example, if I may. So the statute itself is broad and broadly and doesn't direct a cost benefit analysis. So I think HUD does have significant leeway to determine what standards of safety and habitability should be. What is, and this is my second point, what is very different between this case and the example Your Honor gave, and also between prior actions HUD has taken and the example Your Honor gave, is that HUD here isn't regulating conduct that really concerns only the individual choices being made within the unit. So HUD didn't say here, we're prohibiting smoking because we think we have jurisdiction to protect people from themselves. That's not what this rule does. That's not what the prior tenant obligations that are at 966.4F do. What these standards do is ensure that tenants are using their own property in a way that doesn't undermine the health or safety of other tenants. And so I think directing families, to feed their children nutritious foods or telling people they can't drink sugary beverages is really different in kind from the rules that we're talking about here and that we've seen previously. These are not parochial in that sense. They are in keeping with general conditions of safe enjoyment. You can't have raucous parties. You can't be aggressive. You can't let your trash pile up in ways that really undermine the ability of others to go about their lives and safely enjoy the use of their own units. And this rule is entirely in keeping with that general framework.
This is not the government as the nanny state, it's the government as the landlord.
Precisely, Your Honor. Precisely. And HUD has long inhabited that role in the context of the spending clause legislation, where of course it's not regulating directly, but attaching these conditions of safety and habitability to the federal funds that it's offering the public housing agencies. And there's
to what degree are PHAs dependent, recipients, I should say, of federal funds?
You're asking me to agree to that premise?
No, I'm saying to what degree?
To what extent, to what degree? I'm sorry. That's not in the record here because it hasn't been litigated. The funding is not insignificant, but there's nothing here to suggest that it rises to anything like the level seen in NHIB, NFIB, which was the only case where the level has been found to be coercive. And there, significantly, it was not only that the funding levels were so extreme, consisting of more than 10% of a state's total budget, it was also that the requirement at issue fundamentally changed the term of the program. And the court relied on both of those factors in finding coercion. Here, neither is present. In addition to having nothing to suggest funding at that level, this is the program term does not fundamentally change the program. This is not a new program. It's another safety term in keeping with those that have previously been imposed in these leases.
Can I revisit your conceptualization of what HUD's authority is. So do you say the same thing even if we're talking about unattached units? It's one thing to have a raucous party or a bonfire or whatever in an apartment building. One could say it's another to have it in a separate standalone facility. So why does that get included in or as authorized by this statute?
Yes, Your Honor, a few things. I mean, first, these are a small percentage of the sort of relevant housing units that we're talking about, and they haven't been separately challenged either in this litigation or in the rulemaking itself. No one sort of parsed these out in the comments and said that HUD should be regulating differently. So there's really no big exception. But even if you just look at the risk of fire and the risk of property damage, those are absolutely things that it's within HUD's and the public housing agency's interest to regulate in that sort of proprietary role to ensure that property damage is mitigated to a reasonable extent, and that the conditions being imposed, I think, just sort of stepping back a bit here are again in keeping with what you would expect to see in other proprietary contexts, so that private landlords themselves often impose similar conditions, even with respect to townhome units or freestanding units, which is what we're talking about with the single unit dwellings. So those separate considerations amply support the application of the rule there.
And you don't see anything about tobacco that makes it different. I mean, there are. Mr. Joseph sort of alludes to this at times in his briefing. There are Supreme Court cases and the like that really home in on the extent to which agencies can't regulate tobacco in the same way as they might other kinds of products.
Yes, Your Honor, I think those cases were looking very specifically at particular exercises of authority in the context in which they arose. So if you look, for example at Brown and Williamson and the question whether FDA could start regulating tobacco as a drug, the court wasn't asking sort of generally, was it appropriate for agencies to regulate tobacco? It was, could FDA exercise that specific authority under the Federal Food, Drug, and Cosmetic Act? When doing so, would applying the standards of that act would effectively lead to banning the product, which it was clear from reference to other statutes that Congress didn't intend. So again, there's no sort of general notion out there that agencies can't regulate matters affecting tobacco. It's that agencies have to exercise the authorities that they have. And here, HUD did precisely that. It has clear authority to establish standards of safety and habitability, and the administrative record spells out the three distinct ways in which the rule against smoking in and around housing promotes the safe and habitable public housing stock.
Ms. Powell, you don't have to run out the clock.
Thank you, Your Honor. If there are no further questions, we ask that you affirm.
Thank you, Ms. Powell. Mr. Joseph, why don't you take 2 minutes for your rebuttal? You're muted, Mr. Joseph.
Thank you. To Judge Jackson's question about single family units, that's addressed at 397 in the joint appendix. So I disagree with Ms. Powell that it wasn't raised below, and before the agency. To the question about reliance on funds at page 22 in the blue brief and joint appendix 300 to 318, we addressed the reliance. By the way, this is not a situation where they can just terminate funds, which are about almost half of the housing funds for the PHAs. So it's not a percentage of the state budget. But for the PHAs themselves, it's a huge percentage.
And you said that's in the record of 318?
JA 300 to 318. Yeah, this is part of it's our post judgment motion. You are allowed to take judicial notice on appeal. We cited that as well. The statute here is general. It's more like the Occupational Safety and Health Act than like the Safe Drinking Water Act. And so we discussed NRDC versus EPA, where the agency has this authority to figure out what's best. versus the OSH Act in the benzene case, where it's like, look, safe doesn't mean risk-free. This is a general statute. And so that there's that tension. I don't think their statute goes as far as they're claiming. Interestingly enough, they also, during the, and this is, I don't have the page number right now, but it is in the brief. They were asked by OMB some questions, and they said, well, if you're asking us, we don't know. And the point being that they're not experts in this field that they're trying to regulate. So they don't deserve deference, and they don't, their statute is not as loose and as deferential as, say, the Safe Drinking Water Act or the environmental statutes. That's not their role. I am just quick, nanny state versus landlord. They are the regulator of the landlord. They are a nanny state here. My time is up. May I continue?
I'm looking at 397 of the JA, single family housing. Can you direct me within that page?
Okay. I don't usually use two screens since I'm having trouble getting my cursor to move from one to the other. I apologize. Maybe it's best just to read it here.
Where is it on the page? Can you tell me that?
Oh, okay. I'm in the right. I'm sorry. I'm in the right ballpark now.
Looks like maybe the right column. Well, the smoke-free policy will also apply to scattered sites and single family.
Yeah, and single family units that not lead to smoke intrusion. So they were asked about single family units. Right, that's exactly right. While smoking in single family units does not lead to smoke intrusion in adjacent units, the risk of fire and increased. Oh, so
they
point
made
being,
they made just the point Ms. Powell suggested, that where you have single family units, there's still the risk of fire damage, and that's what they invoked.
But I don't believe that's what Judge Jackson was asking. I mean, she's the owner, of course, of her question, but I thought she was asking about why are you concerned about inter-unit transfer when you have a standalone building?
The answer was, well, we're still concerned about fire damage.
Oh, and right, and so they had several opportunities to raise the concern about smoke transferring between units, or smoke being exposed to people within your own unit, that is your own household members, but they didn't raise it, which we argue suggests that the concern about intra and inter-unit transfer is pretextual. They just, intra-unit transfer is pretextual. They weren't concerned about that. They had several occasions where they could have cited that, this being one, but they didn't.
Okay. I'm sorry, I thought you were saying that in multifamily units, properties, their concern was with transfer from one unit to another, right? And Ms. Powell we just discussed that, she and I, and here there is no other unit in a single family. And so the inter-unit concern goes away. And as she points out, the fire safety and damage concern remains.
Right, and I'm sorry, what I was speaking to was they raised in the district court, and the district court adopted the idea that they were also concerned about intra-unit transfer. So
that's going back to the nanny state, you say.
That is going back to the nanny state. That that was pretextual.
Certainly, the emphasis here that I took away from this all was on inter-unit transfer. Certainly, that's more compelling in any event.
And then last, if we are at last, they don't merely have the authority to cancel funds. They have the authority to take the building. So if you ever took any money from them, and then they come up with a new requirement, they not only can terminate your funds 100%, which is, as I said, almost half of the PHA's budget, but they can take the building, they can take title to the buildings. That is coercion beyond anything.
Mr. Joseph, are you suggesting that that is only the case with respect to this particular condition?
No. Well,
to be naming or focusing on effects that apply to all these other conditions as well, right?
Well, right, and those other conditions presumably were done for the benefit. I mean, if you're raising a timeliness argument implicitly there, this is the first.
No. What I'm raising is the concern that you seem to be suggesting certain things are so unusual and untoward that here we now have them regulating lifestyle. And Ms. Powell responds, that happens all the time. Here's a bunch of other regulations that say no garbage, no, you keep your apartment clean, right? And then you say, well, if a person smokes and they violate this, you have the Fourth Amendment concern, and you say that the remedy could be that they take the building away. But presumably that's the remedy with respect to these other conditions as well. So there's the only new thing here is that they've added a condition concerning smoking, but with respect to things like remedy, that's always been the case.
That doesn't make, well, but again, this is a new condition after the other ones. By the way, I mean, taking out your garbage is habitability. That seems fair to me. But to the extent that there were these other conditions that my clients didn't challenge, they're challenging this one because it matters to them.
I understand that, but has any public housing authority ever found its building taken over by HUD because they violated or failed to enforce some of these tenant terms that are meant to protect habitability of other tenants?
The point is they feel compelled. I mean, no, the answer is no, because they're going to follow it. And but if it's outside HUD's authority.
That's a fair answer. That's a good answer. I like that.
Hey, let me make sure there's no further questions for you, Mr. Joseph. Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 20-1068 et al. American Public Gas Association petitioner versus United States Department of Energy. Mr. Day for the petitioner Spire Inc. and Spire Missouri Inc. Ms. Wiener for the petitioner Air Conditioning, Heating and Refrigeration Institute. Mr. Starcher for the respondent. Ms. Wu for the intervener Natural Resources Defense Council.
Morning, counsel. Mr. Day, please proceed when you're ready.
Thank you. May it please the court, Barton Day for petitioners. I'd like to address two related reasons why the court should set the rule aside. My co-counsel will then address reasons why vacator is warranted in this case. It's undisputed in this case that DOE could only adopt the standards at issue if it made a determination based on clear and convincing evidence that the standards were economically justified. DOE admits that its justification for the standards was inadequate, and it was. Not for the reason of inadequate explanation as DOE now suggests, but because of a basic failure to engage in reasoned decision-making. DOE claimed that the standards would provide economic benefits for consumers, and it based its economic justification for the standards specifically on that claim. However, there were obvious reasons to doubt the basic premise that the standards in this case could provide economic benefits. Commenters argued that there was no basis to conclude that economic benefits would result. And DOE offered no information or argument to the contrary. It did provide an analysis, and its analysis showed economic benefits only because it was based on a facially unreasonable assumption that grossly overstates the potential for standards to provide economic benefits to consumers. Commenters challenged that assumption as completely absurd and unsupported by any evidence whatsoever, and DOE did not even attempt to justify it on the merits. That's a failure to engage in reasoned decision-making.
Mr. Day, I'm sorry, can you just be a little bit more specific? So what assumption are you talking about? Is this the imperfect or irrational consumer assumption. Is that what you're referring to?
In the modeling with respect to the economic analysis, yes.
Okay.
And I'll get back to that in a moment. What I'd like to do is address these issues in a little bit more detail. There are actually two related issues here, as I suggested. One is that the basic premise of efficiency regulation is that consumers are leaving economically beneficial efficiency investments on the table, and that's the problem to be resolved here. The problem is that DOE never examined that question at all. It simply has a standardized analysis. It plugs the numbers in, and it crunches the numbers. And what actually happened here is we were all scratching our heads trying to figure out, where are these benefits coming from? And the result, it was dug out of the analysis by a consultant. It turned out that they had this assumption embedded that generated artificial economic benefits. But let me address the basic.
The assumption being that the purchasers were not concerned with economic gains.
More than that. The assumption, actually, the way it plays out is that no matter what the economic stakes are, purchasers acting on their own are no more likely to make even the most economically beneficial efficiency investments than they are to decline them, and are no more likely.
Totally indifferent to this consideration.
I'm sorry?
That they're totally indifferent to this consideration.
Yes.
Okay. And these are commercial purchasers.
I'm sorry?
They're commercial purchasers, not homeowners.
Exactly. And that's the facts here are very important. Commercial packaged boilers efficient enough to satisfy these standards are already available on the market. They already have a significant percentage of all product sales. And those investments are not necessarily beneficial for the purchaser. The economic outcomes of those investments vary considerably. In some cases, they provide significant economic benefits. In others, they impose significant net costs. And as you were just pointing out, commercial packaged boilers are substantial pieces of equipment. They're typically purchased as capital investments by business or institutional purchasers that routinely consider the economics of this type of investment and act in their own economic interest. So commenters made the obvious point. Under these circumstances, there's every reason to believe that purchasers of commercial packaged boilers have a tendency to make investments in these more efficient boilers when it makes economic sense to do so. They have a tendency to decline those investments when they would impose net costs.
Can I ask you a question?
Go ahead.
Thanks. There is a reference in the regulatory materials to a couple of arguable market failures in the sense of informational asymmetry or the lack of reliable information and these misaligned incentives. And so my question is just a conceptual one. Suppose, just hypothesize that we agree with you that there's a fundamental question here about the soundness of the assumption that's reflected in the use of a random array. But then suppose the agency were to say, well, we actually think the random array turns out to be a reasonable approximation because there's no perfect information here. And when we look, and they have a sophisticated analysis that says when we look at the degree of informational asymmetry or the unavailability of information, and we take into account the misaligned incentives, we think that the random array actually gets us pretty darn close. And they expound upon that and say that therefore by clear and convincing evidence, we find that the findings that you think are required to be made by clear and convincing evidence are in existence. You don't disagree that conceptually that would be okay. You might disagree that factually they might not be able to make that assessment in a way that's sufficiently sound, but conceptually that approach would work, right?
Yes, that's correct. The problem here is that these issues were pointedly raised and simply ignored. The references that you're referring to are stock language that show up in every efficiency standards rule. They're not even in the economic analysis. They're in the part of the rule that goes through the motions of responding to executive orders indicating that agencies have to identify what the issue is that they're supposed to address. And if you look at that analysis in the face of all this pointed comment that there's no reason to think standards would provide economic benefits, they don't even refer in discussing those sort of generic market failures to commercial package spoilers. So it's a situation where, in response to the suggestion that they simply failed to address these issues, they had no response at all. And again, it's difficult to understate the extent to which the assumption that purchasers never consider the economic impact of their analysis has on the analytical results. And in this particular case, there's a figure on page 56 of our opening brief that illustrates the basic problem, which is there's a wide range of economic impacts of individual investments. And so the justification for a standard is going to depend on what's the distribution of those outcomes that purchasers leave behind acting on their own. And without looking at that question, and DOE made no effort to look at that question, you end up with a situation where here you've got standards that are pretty close to break even, and they're justified only because of these extreme outlier economic outcomes that are the most likely outcomes to be influenced by economic considerations of the purchaser. They used the same kind of analysis in the residential furnace rulemaking, and there was an extensive technical study done actually breaking out all the data points they used, et cetera. And the bottom line in that case was that over half the regulatory benefits that were being claimed were in cases where the more efficient product had lower installed cost. It was the low cost option. So the whole premise that standards are necessary because people only focus on initial costs didn't even apply. And yet—
Can I ask you, Mr. Day, do you have an alternative? My understanding was that the sort of modeling that you all did was not supposed to be a substitute for the Monte Carlo method or whatnot. So are you suggesting that there's a particular kind of analysis that the government could have and should have done to capture what you say is a problem with the analysis that they did?
Yeah, and there are many things they could have done. I think in this particular case, if they simply went through and said, okay, we're not going to count as results of a standard purchases where the installed cost of the more efficient product is the low cost option, I think that would probably be enough to show that the standards were not economically justified.
Well, of course, that's not their goal. They're not. There might be ways that they can adjust it to reach the conclusion that you'd like to see. I'm just asking from the beginning, are there ways that they can account for what you say is, the market forces at work that they've left out of this analysis, no matter where that leads ultimately?
Yes, they can. And the factor I suggested was specific to one type of outcome, but really—
The 10% top 10 percentile?
I'm sorry?
Was that your suggestion of ignoring the top 10 percentile?
No, because I don't know, there's no way to tell from looking at the data that they provided where the cutoffs are. All I needed to do was come up with some reasonable way to account for the fact that as economic benefits get higher and higher, there's a greater chance that those investments are going to be made by consumers acting on their own. And as net cost situations go deeper and deeper, the odds that purchasers would make those decisions on their own go down.
Right, and I'm just asking, do you have an idea what that reasonable way would be? Because we also have this concept in the statute of practicability and whether or not the government actually can do anything more to perfect its analyses. So is there some clear thing that they could do to capture this concern?
Oh, absolutely. I mean, their model is set up to do that. And that's why we couldn't figure out where the problem was. There should be an algorithm that simply tries to capture what the model looks like, what consumer purchases look like in the absence of standards. And that comes down to where they assign base case efficiencies. And instead of having an algorithm in there that was designed to show what the market is probably like, there's just a random assignment function. So the fix is very easy. It's completely consistent. There's nothing wrong with the model. It's just the garbage that went in. That's the problem.
Was this a similar problem with regard to shipments?
No, the shipment issue is different because the way they do their economic analysis, they look at all these individual variations on installation. So they do an analysis of the economic impact of efficiency investments in a wide range of individual scenarios. And then they look at those individual outcomes called life cycle cost outcomes, and they generate an average of what the average life cycle cost impact is. And shipments it goes to the issue it goes to two issues, but in determining national impacts, it's how many investments would occur as a result of the standards. That's the issue. How many of these more efficient products are out there already? So you multiply the number, the average life cycle cost result by that number of efficiency investments to get the national impact of the standard. And the issue we focused on is that average life cycle cost outcome is driven by these extreme outliers that are likely to be influenced by the decisions consumers make on their own. And yet that drives the outcome that turns a marginal break-even kind of standard that if you look at how purchases are made is probably going to be a negative LCC outcome and turns it into a positive life cycle cost outcome. And that's the fundamental problem with the analysis.
Can I just ask one more question? I'm wondering if you ever concede any sort of irrational behavior by consumers, because it would seem to me that you would never have economic justification if consumers always acted perfectly rationally, right? So there is some world in which we're going to have these big institutional consumers not doing what is in the economic.
Absolutely. And I would concede that in the case of commercial packaged boilers, there are going to be some cases where consumers don't make sensible economic decisions, but it's not a binary. And that's the false conflict that DOE set up in responding to this. They said, well, we can't assume that people are making perfect decisions all the time. And so we're going to model a world in which these issues are not considered at all ever. And that is just ridiculous on both ends. I think the appropriate thing to do is to try and get a sense. And again, I think it's a matter in this case of simply recognizing that as the economic stakes go up, the probability that economics are going to affect the decisions that consumers make goes up. And to your broader point, the solution is not one size fits all. I think you have to look at the circumstances with respect to the product at issue. And here, we're dealing with a particular type of product where the usual sorts of factors that one would be concerned about in terms of justifying a standard just don't apply. And that's not the case for all products, not by any means.
Thank you, Mr. Dave. Let me make sure we don't have further questions for you at this time.
No.
Thank you very much.
Hear from your colleague, Ms. Weiner.
May it please the court, Stephanie Weiner for petitioners. Given that it's not disputed that the clear and convincing evidence standard applies to this rulemaking, and given that the department agrees that remand is required, I'm going to focus my time today on why the final rule should be vacated. Vacatur, which is this court's normal remedy, is required under the Allied Signal test for two reasons. First, vacatur will not be disruptive. It is what Congress intended should happen in this circumstance, and in fact would prevent the disruption caused by leaving the rule in place. Second, vacatur is necessary to remedy the department's serious legal errors, particularly in light of the statute's anti-backsliding provision. First, vacatur is not disruptive here. This is what Congress intended to happen. There's no disruption because these standards have not yet gone into effect. There's nothing to unwind here. There's no egg to unscramble. If you vacate the rule, these products will remain regulated. They're regulated at the efficiency levels set by the Society of Engineers, codified previously by DOE, and those are the basis of building codes around the country. And that's exactly what Congress intended to happen.
Is it not the case that the industry is taking preparatory steps on the assumption that more restrictive requirements are going to be in place?
I think there has been an overhang over this rule due to litigation. And while, I represent a trade association that has multiple members, I can't speak to what any individual member has done. But the department itself has estimated that it would cost the industry $21.2 million to bring equipment into compliance here if these rules are left in place. And I believe some manufacturers want to know whether if these rules are in fact unlawful, as the department says that they are, and remand is required. We believe that that is disruptive enough and the industry should not have to incur those costs for rules that the government has said unlawful and may go away on remand.
Well, can I just ask you, because I was curious about your point concerning what Congress intended. As I read the statute that underlies this whole thing, Congress, it seems to me, clearly intends for these standards to be revisited and potentially revised, even when the society itself, whatever the private organization is, doesn't touch them. So it almost seems like maintaining the status quo is against the intent of Congress. I mean, the no rule world. Because Congress says every 6 years, we really want you to review, revisit, and potentially increase. So how do you reconcile that with your conception that Congress does not want change, does not want disruption in terms of the imposition of a rule?
Congress clearly wanted the society standards to be reviewed and revisited, but it specifically said what needed to happen before more stringent standards could be adopted. And what it said was the agency had essentially two choices. Either it found clear and convincing evidence to support more stringent standards, in which case they could go into effect. But if the department failed to find that those standards more stringent than those in place around the country were not supported by clear and convincing evidence, then the default rules, the Society of Engineers standards, were to remain in place. Sorry, there's a little feedback on my end. And that's what's happened here. The department has said it did not make the clear and convincing evidence standard required by the statute. And in that instance, I think the statute is quite clear that it's not the department shouldn't on remand go back and do it correctly, but the standards should not remain in place in the meantime, because Congress was very clear about what had to happen before they could go into play.
All right, well, setting aside what the department is now saying about what the rule determined, the rule itself indicates in many places that the agency was making this determination, that it had found economic justification by clear and convincing evidence. And so given that now, the question is whether or not, even though we have these potentially meritorious challenges to the manner in which they found it, to their explanation for some of the data, aren't those kinds of defects readily curable such that, when it goes back, we're not talking about ripping out the fundamental underpinning necessarily of the rule. And so in the interim, under Allied Signal and the like, everybody's on notice. This is what the department has found, and we should just keep going with the rule.
Well, the department has not, in our view, found that these standards are supported by clear and convincing evidence, and that's because they have failed to actually apply that clear and convincing evidence to the standards that they adopted. What happened here, Your Honor, is there was a notice of proposed rulemaking that said, we believe tentatively conclude that these standards are supported by substantial evidence. Commenters raised arguments in the record, including those made by my co-counsel, which the department has yet to defend in this court, to say that there was not clear and convincing evidence for the standards. And the department, in its final rule, instead of addressing that, said, we do not believe that the clear and convincing evidence standard applies to this rulemaking after all. As to the references to
before you leave that, that's not all the department says. The department says that in a footnote, but it's not clear at all that the department actually applies any different standard when it's doing its analysis. And there are several places in the actual final rule, JA 583, JA 590, 591, 658, where when it is making findings, it says we find by clear and convincing evidence X. So at a minimum, we have some sort of ambiguity about what standard they were applying, but one could argue that notwithstanding the footnote that talks about the potential for some other standard rather than clear and convincing evidence, they were in fact making findings by that standard.
Or so saying anyway.
Or so saying it.
Yeah.
Precisely. So with respect to those references, it is our position that particularly with the department saying that it did not actually apply the correct standard, that those references under this court's cases, referencing a standard is not the same as considering it. Stating that something was found is no substitute for finding it. And while we acknowledge that there are places where that the clear and convincing words were used, we do not believe that the department actually held itself to that standard. And I would suggest, standards of evidence matter, right? As this court knows well. And one place that you could see what the department actually held itself to here is if you look at the conclusion of when the department summarized the rule, which is on JA 582, right? Where after going through all the key findings in the record, the conclusion paragraph does not include the requisite clear and convincing evidence standard. And if you compare that, for instance, to rules that interveners cite on page 6 of their brief that were held where the department did find clear and convincing evidence, those corresponding concluding paragraphs stated that expressly.
Yes, understood, but I guess I'm confused as to what they did then, because they don't ever say another standard, and it's hard for me to wrap my mind around the argument that just because the agency failed to meet what we now all agree as the test means that they were in fact applying a different test, as opposed to they just didn't get to the requisite level. In other words, it seems like you're making a separate argument that, you know, we have reversible error as a matter of law because the agency was applying a different test, as evidenced by the fact that they didn't meet the applicable test, but not as evidenced by the fact that they actually said we're applying some other thing.
I think we are saying that they didn't actually meet the applicable test because they didn't apply the right standard, which is in the rule itself, Your Honor, not just the footnote. It says clear and convincing standards need not be based, in this rule, need not be based on clear and convincing evidence.
That was in the alternative.
In the alternative, we believe the references.
This is not complicated. They said they reached this conclusion by clear and convincing evidence. A later repudiation of that by a later brief is not the same as rescinding it. They've said it. It's out there. They also said an alternative. If we don't think the alternative applies, they have to meet the clear and convincing standard.
We do believe they have to meet the clear and convincing standard, and we do not believe that they have done so, which is why we don't think this
That's
is
the only fair point that you can make.
Exactly.
Everything else is irrelevant. Either they did or did not meet the standard that they purported to, and that we all agree, seems to agree anyway, is the appropriate standard.
we believe, sorry, Your Honor, we believe that they did not, and that's why we believe that remand with vacatur is required, because when the department goes back on remand and takes into account the concerns that my co-counsel has raised and creates an updated record for things like gas prices, which were inaccurate, we now know.
I guess the bottom line is it's different to say, and this is salient for applying allied signal. It's different to say they thought they met clear and convincing, but they didn't mean it. They didn't meet it. And then you could go on to say, and they never could, and therefore you ought to vacate. That's different from saying they thought they were applying clear and convincing and they didn't even apply it.
No.
That argument is a feature of what you're saying, and it's a feature of what the government has said in its briefing too. And that one is just hard, because when an agency says it's applying clear and convincing, I don't know what else to infer other than that they are. Now you might well be right that they haven't met it. They thought they met it and they haven't met it. But to say that they didn't even apply it is a little difficult when they tell you in the alternative that actually clear and convincing, to the extent that's the relevant standard, is satisfied.
We believe the department has said that they did not apply the correct standard, even in their most recent brief.
Right. They said they didn't apply the correct, which just further the point, because the correct standard is clear and convincing.
Correct.
The government's own argument, under the agency's own argument. And the agency said in the rule that in the alternative, to the extent clear and convincing is the correct standard. We don't think it is. That's what they said at that time. But to the extent clear and convincing is the correct standard, clear and convincing is satisfied.
But even if that is correct, it is argued that on remand.
Why do you say even if? What's even arguable about that? Because that just.
Oh, I agree. Clearly, the department used the words clear and convincing evidence in the rule.
Yes.
I agree.
So you have an agency that's telling us that
yes.
the convincing standard was met.
Well, what the agency is telling you is that they did not apply it in a way that can be sustained by this court.
That's not in the rulemaking. That's in a subsequent brief.
Right.
The rule itself is, in our view, does not apply the correct standards because that evidence is not there to support.
That's different.
That's fine. Just forget the stuff about later reporting.
I believe that is the case, that the evidence, as my co-counsel has discussed, does not support this alternative finding, whatever the department is saying now, I think is what you're directing me towards. And I believe that is the case. I also believe that when the department on remand takes up this rule, it needs to do a new rulemaking. It needs to update the record. And when it does that, Your Honors, in our view, and addresses the concerns raised by my co-counsel and updates the record, we do not believe that it can adopt the same standards on remand. And as a result, it would force manufacturers and the industry to incur costs that for a rule that is unlawful and that would otherwise go away.
Okay.
To the extent.
Can I just, I know that your time is out, but I'm so curious about this anti-backsliding provision argument, because it seems odd coming from your side of the table to suggest that on remand, the government would not be able to, as per that provision, change the standards.
So our concern is that because the anti-backsliding provision is written, which prevents the department from relaxing standards once they are in place, our concern is that the department or others may believe that the department cannot change these rules if they are not vacated on remand. And if that's not the department's view,
if the department is revisiting them, they're still in effect, but they're doing so under a constraint of a judicial order. It seems to me that your concerns are not very weighty, and they can certainly be addressed by the court's order itself.
And surely that's not your position. I hear you saying we're just worried that the government might take that position and therefore not change.
Correct. Our concern is we don't know what the government's position is on that because it wasn't addressed in the briefing. We believe that absent we believe it could be an open question. We have not found a case in which a standard was remanded without vacatur and how the anti-backsliding provision.
I assume your position is that if we were to remand without vacatur, your position would be, well, don't be constrained by the anti-backsliding provision. You can do whatever you'd like because you have a judicial opinion that requires you to revisit this.
Yes, we would, our position would be that the department should follow this court's order on remand. And if the court's order said that, or more broadly, we believe the department should have a clean slate on remand to conduct a new collection of evidence in the rulemaking and make the determination that the department, in our view, has not met the clear and convincing evidence, that has not found sufficient clear and convincing evidence to support the more stringent standards. That's why we believe the rule should be vacated, because otherwise, the entire industry will have to take steps to comply with a rule that may or may not stay in place on remand. And we believe that is, under this court's allied signal test, a reason why vacatur is required, right? We need to enable the department to make the determination that was required by the statute in the first instance without any overhang of anti-backsliding and prevent the disruption caused by leaving the rule in place.
We have trod this ground several times now.
And with no further questions.
Thank you, Ms. Weiner. We'll hear from respondent side now. Mr. Starcher.
Yes, good morning, Your Honors, and may it please the court. As already discussed, there's agreement at this point that the clear and convincing evidence standard does in fact govern these kinds of rulemaking. So I think the most sensible place to start is with something that was touched on briefly during Ms. Weiner's time, which is the adequacy of the alternative conclusion given in the rule. I certainly agree with the panel's indication that it is an alternative conclusion, that it was presented as such. And that the court has to address that alternative conclusion and to deal with it. But as explained
I'm sorry, I don't know that I'm persuaded that it was an alternative conclusion. And so can you just spell out why that seems to be your position?
Right. So I think the best way to get there is to look at where this discussion appears in context. And if you look at where this assertion about whether or not, I have the JA site here, this assertion about whether or not, it's J1, 591 to 592, I believe. Yeah. This assertion about whether or not the clear and convincing evidence standard applies during these sorts of 6-year lookbacks is provided in response. The rule first summarizes comments received from some of petitioners here about whether or not the evidence presented to the agency was, putting aside whether or not it could meet the sort of normal evidentiary standard of preponderance of evidence, whether or not the evidence presented here could meet this heightened standard, and whether or not there were certain features of the evidence in front of the agency that would render it insufficient under clear and convincing evidence. And the first response given to those comments is DOE reciting the text of the relevant 6-year look-back provision, and then stating both above the line and in an extended footnote, there are features of this statute that indicate to the department that clear and convincing evidence is not required during the 6-year look back.
Okay, can I just stop you right in that point, just to say that because this was a response to a comment or a question, does not to me signal that in all the prior discussion and all the discussion subsequently, DOE was actually applying a different standard. It's sort of like a person pops up, they're doing something, they're talking about it, they're saying in 583 before this that they are making certain findings by clear and convincing evidence. And someone says, wait a minute, are you sure that clear and convincing evidence is applicable in the 6-year look back context? Footnote, long musing about circumstances under which it may not be. But in any event, they say, I see it as in any event rather than alternatively, because I don't know what other standard they would be applying. Did they say what else they were doing in the rest of the rule?
So the alternative standard is the default standard in rulemaking, which is preponderance. And again, I think that was the sort of the thrust of these comments they were responding to was certain commenters had suggested during the comment period that when you're under a clear and convincing standard, certain kinds of evidence or certain kinds of assumptions cannot be made by the agency in engaging in rulemaking when you're subjected to that higher evidentiary standard. But I think
anywhere in the rule, do they have the 2 or 3 pages or paragraphs going on to describe preponderance in the way that they do clear and convincing?
No, and so I do think I think there's agreement that the court has to look, whether you call this an alternative conclusion or a principal rationale, or an alternative rationale, or the only rationale. There's the department doesn't disagree that the court has to look at the adequacy of this alternative explanation that was, whether or not we call it alternative, the explanation that was given. And I think, if you look at what is actually said about the clear and convincing evidence standard in the rule, in the entirety of the rule, there are these 2 to 3 paragraphs that essentially describe in general terms what the department understands that standard to require, and then proceeds to just state both in these pages that we've talked about and also the pages that the department refers the court to, where later on in the rule, again, the words clear and convincing evidence are used. It's a reference to a standard and then a conclusion that the standard is met without any sort of explanation or reasoning about why that standard is met.
Can I ask you another question in a similar, where else in the rule does it ever say we find by a preponderance of the evidence that X, right? I would hear you that they're doing 2 different things or that this is an alternative if there's any evidence of actual application of another standard.
So the pages that we focus on are the only place in the entire rule where the implications of this higher standard are discussed at all. And so it's perhaps not surprising that there's no later point in which preponderance is described or sort of expounded upon. I would point this court, I think it's helpful to just compare what the agency did here and its discussion of clear and convincing evidence here to the agency's discussion of clear and convincing evidence in the last time that the agency looked at commercial packaged boilers, which was in 2009. And there in that discussion, there was, granted that was a finding that the clear and convincing evidence standard was not met, but in some ways you'd expect less discussion when they're finding the standard not met when they're finding it met. But if you look at the discussion that occurs in that rule, there is, it's not just clear and convincing evidence requires X, we believe that to be met. It's under the clear and convincing evidence standard, here are a number of specific pieces of data or factors. In that rule, they identified a relatively small, LLC, they identified things they weren't sure about. This is 74 Federal Register.
So I think, I'm sure it's right that you can there's either real world situations or you can imagine situations in which the incantation clear and convincing is repeated often. So it just brings home that clear and convincing is being applied. But the agency said that it was applying clear and convincing. It just did. I mean, if you look at JA 658, the paragraph, this is a concluding paragraph. This is the end of the entire analysis before it gets to summary. After carefully considering the analysis results and weighing the benefits and burdens of TSL2, and based on clear and convincing evidence, setting the standards represents a significant improvement that is technologically feasible and economically justified. It just says that.
Right.
So it seems to me that what you're asking us to do is to say that even though the agency said that, it didn't really do it.
So, I mean,
what's the basis by which we could do that? When a jury says we find beyond a reasonable doubt, they just conclude it.
Right.
You don't need to have an exegesis about why beyond a reasonable doubt, in fact, is a standard, and that's exactly what we applied, and we did something more than preponderance. They just concluded, and we just assume it to be true because they said it.
Right, but I don't disagree with any of that. But you know, there's a line of cases that this court, a line of cases that explain that there is a point at which a recitation of a standard or a statement that the agency did something is inadequate, and that there's a point at which it can be too conclusory or too unclear that the agency actually did it, to the point that that a court is left with the sense or the conclusion or the fear that the agency, despite stating that something was done or was met, didn't actually do the work to back it up. And
I guess one way to think about this in my mind is that suppose you had the exact same conclusions that clear and convincing was satisfied without the ruminations on 591 to 592 about whether clear and convincing in fact is the right standard.
Mm-hmm.
And somebody could come along and say, well, all you have is a couple of conclusory statements that clear and convincing was applied. We've got these decisions that say you can't just recite a standard, you actually have to apply it. That's all we have. And I mean, I guess I would have a hard time knowing what else they were applying if they said they were applying clear and convincing. And then you come back to the real world here and you insert the ruminations about whether clear and convincing in fact is the right standard. It seems to me that after the agency engages those ruminations, it's all the more telling that they in fact say clear and convincing, because they've already engaged with the possibility that they might not apply clear and convincing, but yet the conclusion says they did.
I understand those concerns, and I certainly agree that this is in some ways a difficult application of this line of cases about when something is too conclusory or too scant to provide the assurance that the work was actually done. But there is that line of cases, and I think while this case is different from those line of cases, particularly when coupled with the proximity of this discussion to what now everyone agrees is, an incorrect assertion of authority. I think the totality of this discussion that appears on 591 to 592 does fall within, the kinds of concerns that animate these courts, this court's cases, which are cited in the brief, in which the concern is that there is a recitation of a standard without a meaningful application. But that being said,
can I also focus our attention on what is actually said about the possibility of another standard? You would expect that in this 591 text, before we get to the footnote or around the footnote, they would say the statutory text indicates that the standard need not be clear and convincing evidence. And indeed, with respect to our consideration of the evidence at issue here, we have not so applied that standard. However, if it is, footnote, explain why they didn't do it. If it is, then we would say that clear and convincing even,
right,
applies under these circumstances. I see no affirmative representation that the agency is doing anything other than applying clear and convincing evidence. And in fact, the footnote just muses on the possibility that they really didn't need to go as far as they actually did.
Right.
That's how I read that.
And I don't disagree that it's what the footnote and the statement above the line were intended to do is to some extent ambiguous. But again, I just returned to, those were the first level responses given to a series of comments about the clear and convincing evidence standard. I don't think there's any disagreement that the court does in fact have to grapple with the statement that clear and convincing evidence was satisfied. I am happy that, I see my time is out, and I do want to move on to some of the other features in this case, particularly.
Well, talk about the remand. So what is, so fine, let's say we agree with you. Why does that have implications for whether we vacate, whether we don't? You say don't vacate, but does that mean that on remand, you would do the kind of fulsome whole start from scratch review that Ms. Weiner is talking about? Or are you just going to go back and like insert the right standard or cross out footnote 21?
So I can't definitively commit to anything that the agency would or wouldn't do on remand. I think, if you look at this court's decision in EMA Homer versus EPA, there's a discussion at the end of that decision that is a case where remand without vacatur was utilized. And at the end of that decision, the court notes that what happens in remand without vacatur is on remand, the agency, petitioners, other parties, can do a lot of different things. They can stick to the exact same record and just provide more explanation. They can engage in further comment. They can update figures to reflect changes that have occurred since the rulemaking took place. And so any or all of those things could happen here, which is, I think, precisely why, and I think this is equally true for the sort of methodological challenges that petitioners raise. This is a rule that if the rule will be sent back to the agency without vacatur, different additional things could be said, different explanation could be given about why the methodological choices that have been, the focus of petitioners' challenges here are in fact justified. I'm happy to talk about those if the
Why doesn't that hurt you and not help you, right? Why doesn't the uncertainty make it worse from the government's perspective of you should leave the rule in place? Ms. Weiner says we have people who are relying on this. We have people who are spending millions of dollars. So maybe, I don't know if she's saying this, but maybe, Your Honors, if the government commits to just sending it back and scratching out Rule 21, footnote 21, then it makes sense to keep the rule in place.
Oh, I see.
If they could come back and redo the whole thing, then you should actually wipe it off the books. Because it's not fair to us and we've got reliance interests.
Right. So to be clear, the sort of ambiguity I was talking about, or the uncertainty I was referring to, is not uncertainty from the agency's perspective and the ultimate conclusion that will be reached. So this is, as represented in the agency's supplemental brief, at this time, the agency does have full confidence in the record, understands the sort of challenges that have been raised in this litigation, but does, fully expects on remand to ultimately reach the same conclusion. What I was referring to in uncertainty is, exactly how will they get to the same conclusion? Will it be, as you suggest, sort of a crossing out paragraph or footnote 21 and then providing additional explanation of clear and convincing? Will it be, will there be changes made to the model? I mean, those are questions that I can't answer. But again, the agency
they prejudged it and they'll figure out a way to support it.
Certainly not. Again, that's why I can't speak definitively. But of course, this is, this court deploys remand without vacatur frequently, and certainly not infrequently in environmental cases, in cases that touch on environmental impacts in particular.
Right, and in some ways, it's not just that you're predicting that the agency would reach the same conclusion in terms of thinking that more stringent standards are justified. It's that you're predicting that the agency would reach the same conclusion that the more stringent standards are justified by clear and convincing evidence, because that's what they said they did. So the fact recitation of clear and convincing evidence actually adds meat to the bone on whether they're likely to arrive at the same conclusion. Now,
sorry.
Let me ask you this question. For the agency to do that, let's just engage in this hypothesis. Suppose we were to agree, and I'm not saying we necessarily would, but suppose we were to agree with the challenge that petitioners make to the main underlying assumption about the random array and whether it's fair to just impose a random array rather than one that takes into account the possibility that purchasers actually make informed decisions and are acting in their beneficial self-interest. If we were to agree with that, and we were to disagree with you that the agency, in fact, didn't even apply a clear and convincing standard, but rather they said they did, and so we just assumed that they did. Mm-hmm. Do you have a substantive defense of the rule?
Yes. I mean, yes, I think that substantive defense largely tracks what respondent interveners laid out in their brief, but it's also reflected in the rule itself. I mean, I guess beginning with the sort of challenge that took up the majority of petitioners' time, which is this the choice to randomly distribute base case models across base case instances during the Monte Carlo analysis. A number of responses, and feel free to cut me off if I'm too far over time here, but a number of responses to the points that petitioners make, many of which are in respondent and intervener's brief. The first of which is this assertion that the random distribution, the choice to engage in a random distribution, is effectively an affirmative assertion that consumers never engage or never consider economic benefits.
Can I cut you off for just 1 second?
Sure.
Sorry, but I do want to hear the summary, the top line summary of the points, but I just want to make sure I understand that the government's position is that if we disagree with you that clear and convincing was only incanted and not applied at all,
Mhm.
that even though you don't have a substantive defense in the brief, that you actually do want us to go ahead and rather than remand for the agency to supply a more elaborate explanation of the rule, you actually want us to go ahead and sustain the rule.
If the court were to get past yes, short answer is yes. Once you get past, I think the only disagreement between the department and respondent interveners at this stage is the disagreement that we've discussed earlier, which is the alternative explanation sort of topic. On the random distribution point, at a high level, the issue here, the issue that petitioners are highlighting is an issue that is not uncommon to Department of Energy rulemakings or really to any other agency rulemaking, which is that oftentimes in rulemaking, you reach a point where there just is no further data to allow further refinement of a model. That is what happened here. The department did have a lot of data that helped inform its base case assignments. I think it's important to keep in mind that this was a random distribution, but a bounded random distribution in at least the following very significant way, which is the department actually knew what types and efficiency levels of boilers were being shipped out to consumers for 2 of the 8 categories, because the industry provided that data. For the other 6 categories, it actually knew total numbers of boilers being shipped and average efficiency levels of those boilers, but did not know efficiency distributions. And that's something that petitioners challenged. But the point being is that the boilers that were being randomly assigned out the department has a lot of confidence that set of boilers is an accurate reflection of what is in the market. And then the question becomes, how do you assign those boilers to individual base cases when there is no additional information, as the agency explains at J622, that would allow the agency to engage in this sort of complex consumer choice model that petitioners now urge, but I think as the panel sort of hinted at no time, including in the briefing before this court, have petitioners ever really come up with any concrete way to actually actualize the idea that you would somehow need to account for this kind of consumer behavior. And I think it's important, petitioners really are relying solely on a common sense, I think intuitively appealing sense of, oh, well, this is a commercial market. We know consumers must be behaving rationally, and therefore this is some sort of gross overstatement of economic benefits. But I think, as the department pointed out, there are a large number of reasons, many of which petitioners don't contest, to think that in fact consumers in this market, both commercial and residential consumers in this market, are frequently, we don't know exactly how frequently, but frequently engaging in behavior that is not strictly economically beneficial.
Okay. So can I just add, we have respondent interveners to hear from, and
right.
Is there a explanation that you think they haven't made that the government has? And if so, can you just give the top line summary of that?
Certainly. So yes. So I think that the top line response is, there's lots of literature out there about the reality, I think the Nobel Prize in Economics in 2017 was actually won for this, the reality that consumers in many markets do not behave strictly rationally, that there are a number of things in this market in particular, for just to give one example, a huge amount of the boilers that go out every year are replacement boilers. So it's like, I think 20 to 25% of any given market is new construction, where people are buying these things in the first instance and making, informed, possibly economic decisions. But a huge amount of the boilers going out every year are replacement boilers, and a huge number of those are what's known as emergency replacement boilers, which is, in other words, a boiler fails in the middle of winter in Wisconsin. It's absurd to think that in those circumstances, the owner of that commercial real estate building is really engaging in this careful, process to replace the boiler. There's evidence and research showing that most emergency replacement and replacements are like for like, which is to say that when a boiler fails, you don't engage in a search for a new one. Really, you just ask someone to come in and install a new version of the one that you had.
Okay.
So that's one example.
Okay, that's helpful. Let me make sure my colleagues don't have additional questions.
I have a question.
Yeah, sure.
Mr. Starcher, the secondary literature suggesting that, and empirical literature, that remands without vacatur often result in essentially no further action being taken. The agency has no incentive to take the matter up again. And so these things languish for years and, again, sometimes never revisited at all. And there's a host of examples involving just the EPA. And here we have the rule going into effect, if it does, without vacatur in 2023. Don't you think we ought to, if we abide by your request not to vacate and remand it instead, that we ought to put a deadline on the agency to issue its revised regulation or whatever it's going to do expeditiously before all this money is spent and the matter is effectively moot?
Right. That's certainly something this court has the authority to do. It has done that in past remand without vacatur cases. Not
How long
often,
do you
not all.
think the agency needs here?
Again, I think precisely because of the sort of pre-decisional problem. Yeah, I can't give an exact number, but I think if the court were to impose a deadline, a reasonable deadline, or to direct the agency to move with alacrity or whatnot, the agency would certainly abide by this court's order. And so,
what if we just said 90 days unless you all come in the next 10 days and show us why you need more time than that?
I can't, without running that by the client, I can't make any representations about whether or not the agency would be able to meet that short of a deadline.
Well, you mean they couldn't within 10 days tell us that they need more than 90 days?
Oh, I'm sorry.
Clearly they could do that.
Yes, likely they would
right,
be
so
able to.
We have a possible resolution of that problem, potential problem.
Mr. Starcher, can you tell us where in the record, if at all, the emergency boiler point comes up?
So there's sorry.
Please.
So there's in one of the technical support documents, I don't know that I have this particular I have many JA sites, but not this particular one handy. There is discussion about the reality that in the market, new shipments account for only like 20 to I think 25, again depending on which category you're looking at. I think the specific detail about emergency replacements, I don't believe is in the is specifically pulled out in the technical support documents, but of course, this court has lots of case law reflecting the reality that when an agency regulates any kind of market, there is some amount of deference due to just the agency's familiarity with the realities of that industry. And so, I'm not sure that again, because the agency did explicitly say there are lots of market failures here and listed a few. I'm not sure the agency was in fact required to list every market failure it could have thought of.
Was the agency required to provide some support for the listing? Yes, the agency listed a number of potential market failure issues, but they remain purely hypothetical, I would suppose, unless the agency also includes in the record some support for it. Here's a study that shows that this sort of thing happens in this environment.
For some of these market failures, I'm sure that literature exists, but I think that question actually highlights an important point to keep in mind, that there was no evidence in the record either about the percentage of consumers, commercial or residential or otherwise, who were actually making the kinds of strictly economically beneficial decisions that petitioners were raising. And so this was in response to an assumption made about how consumers behave provided by petitioners. DOE's response was, we can also come up with a lot of assumptions, but you've given us no data that would allow us to actualize the assumption that you're making and to actually place it in our model. And of course, this court has a lot of cases dealing with challenges such as this, where really the challenge boils down to an assertion that the agency didn't have perfect information or should have pushed further to develop more perfect information or better information, and didn't. And this court has repeatedly said that's not a challenge that this court will countenance. An agency isn't required to go down every rabbit hole if it's satisfied that the evidence it has is adequate.
Okay, let me make sure my colleagues don't have additional questions for you.
Nope.
Thank you, Mr. Starcher. Ms. Wu, we'll hear from you.
May it please the court. Michelle Wu from the Natural Resources Defense Council for Respondent Interveners. This court should deny the petitions for review because the department reasonably concluded that it was highly probable that the standards were economically justified. And I'd like to pick up on some of the colloquy you had with Mr. Starcher about why the department's method of modeling consumer choices was reasonable. In addition to the emergency replacement issue that Mr. Starcher pointed out, the department did explain that there are also other sorts of market failures that are impeding purchasers from capturing the full benefit of efficiency investments. That includes, for example, as the department explained, a situation in which a developer purchases a building and can thereafter sell it for a profit. It also includes, as we pointed out in our brief, situations in which landlords are purchasing boilers and can pass on the operating costs to tenants. So there are many reasons to think that that purchasers of commercial packaged boilers aren't identifying the most economically beneficial investments.
But as a matter of agency responsibility under, arbitrary capricious review and whatnot, to what extent is the agency required to not just theorize about these circumstances, but actually, to some extent, establish that these distortions of the types that you're talking about are in fact happening in this market? Do they have that responsibility, and did they do that in this case?
Well, Your Honor, again, as Mr. Starcher pointed out, there is case law that suggests agencies can rely on their background regulatory experience and their knowledge of the market that they regulate. And in this case, the background of Congress's mandate to set mandatory energy conservation standards is the idea that voluntary market forces are inadequate to advance energy efficiency in the way that Congress wanted. So that's the background of this type of regulation. And then as far as things in the record, I think one thing that supports the agency's assumption of imperfect information or insufficient information is the nature of the Monte Carlo model itself. There are numerous inputs that feed into the agency's model, separate from the ones that petitioners have identified, and show that whether a boiler is economically beneficial for a particular consumer depends on a whole range of assumptions and future values. And even well-informed, rational consumers would have a difficult time identifying which boilers are economically beneficial in the long run. As for misaligned incentives, petitioners' own evidence suggests that in 75% of cases, the person who purchases the boiler also is the person who's paying the operating costs. But that still leaves 25% of purchasers in commercial buildings, not to mention 12% or all residential buildings, which constitute 12% of commercial packaged boiler shipments, where there is more of a problem with misaligned incentives.
So the misaligned incentives and the informational issue, which are the market failures that you're pointing to, am I right that the only place mention of that is made in the rule is at JA 660 in the section that deals with procedural issues and regulatory review under the executive orders?
And there are two other places, Your Honor, where the agency discusses it. The agency, for example, rejected a model put forth or an alternative put forth by petitioners that would have assigned base case efficiencies based solely on economic criteria. And it said that that reflects an overly optimistic and unrealistic working market and presumes information that may not be available to all consumers. That's at JA 621. And then the second point is that at JA 622, the agency explained that developing a model that would have accounted for economic criteria, which petitioners have suggested the agency needed to do, would also require accounting for all the other factors that influence purchasing decisions, including green behavior, government incentives, and things like whether the purchaser is a landlord or a tenant. So, and that's at JA 622.
But there they just said it'd be too difficult, right?
Well, they said it would require information that isn't available and data that isn't available and a way to recognize all of the other factors that influence consumer choice separate from the economic criteria that petitioners have identified.
Can I go back to your answer to my question about the agency's responsibility to show its work and actually amass evidence of the kinds of things that they think are happening? When we're talking about clear and convincing evidence as the standard and a statutory requirement that they evaluate factors to the maximum extent practicable, does that give them more of a responsibility to not just rely on their own background principles, but actually figure out the extent to which these kinds of distortions are happening in the context of this market?
Well, Your Honor, of course, we agree that the clear and convincing evidence threshold is higher than the preponderance threshold. And the agency did recognize that as well. And it said, it concluded that that higher standard was met. It needed to conclude that it was highly likely that the standards would provide economic benefits. But as far as how the clear and convincing evidence threshold comes in, I have two responses to that. The first is that, as you pointed out, the agency is required to conclude whether the standards are economically justified by clear and convincing evidence, but only to the maximum extent practicable. And that's because Congress recognized that this is an inherently predictive exercise that requires the agency to make predictions about future savings and consumer savings based on information that is uncertain. And then the second point is that the Supreme Court has indicated that evidence to meet the clear and convincing threshold need not be mathematically precise or based on definite present or future conditions, and that approximations and reasonable estimates are necessary. And that's from the 2018 Florida versus Georgia case at 2527.
Those predictive judgments, which of course are necessary. We have a record in which the agency predicted gas prices for 5 years, which have now elapsed. We know the predictions were erroneous. Are they obligated now to make new predictions for the next 5 years or whatever it is? Or can they rely on facts that we know have been disproved?
Well, as for the question of the adequacy of this rule, I don't think the agency needs to look at what actually happened with gas prices, because the agency can supply a more comprehensive explanation, if it wanted to revisit it, to justify this rule based on the record at the time and the decision at the time. And that would be an entirely appropriate
and
thing
when
for the agency.
That's challenged and subject to review, we could find that someone could reasonably believe that was clear and convincing evidence when they knew it was in fact untrue?
At the time in 2016. The agency relied on the best available data that it had about gas prices.
That's a pretty low bar. I mean, the Congress has set this thing up so that it's not just ordinary, minimally necessary evidence.
Well, the agency looked at the best data that was available in 2016 from the Energy Information Administration.
But the record, once we remand, the record is potentially reopened.
Well, it could be, but another option, though, and what the agency has requested is an opportunity to provide a better explanation on this record.
Wouldn't the failure to reopen the record, knowing that the data on which it relied are incorrect, make it hard then to be upheld as having clear and convincing evidence?
No, Your Honor, I think because that the rule would still be assessed based on the record at the time. An agency has an option on remand of just providing a better explanation based on the record at the time. But on the point of a remand, I do want to emphasize that.
If we remand it, it's all open.
Well, this court also has the option of structuring the remedy in a particular way. For example, this court could direct the agency to provide the more comprehensive explanation it's asked for an opportunity to provide. It could, as Your Honor suggested, impose a deadline on that explanation, such as 90 days, and then it could adjudicate the dispute with the benefit of the agency's fuller explanation. And that would also mitigate petitioners' concern.
Right.
Right, and that would mitigate petitioners' concerns about the compliance deadline as well, because this court would be, would be able to rule on the motion or on the case expeditiously. And I also just want to make the point that it's critical that any sort of remand be without vacatur in this case under the court's allied signal test. Vacatur would be both disruptive and environmentally harmful. As far as the disruptive consequences, petitioner's own declaration from one manufacturer indicates that it will take 3 years to adapt operations to come into compliance with these standards. Because this 2023 deadline is on the books, and nope, Your Honor, I see my time has elapsed. May I briefly conclude?
You can finish the thought.
And because this 2023 deadline is on the books and nobody has sought a stay, presumably manufacturers across the country are already beginning to adapt their operations to comply with these standards. And it would be environmentally harmful because it would leave less efficient boilers on the market for longer, locking in for those boilers more harmful pollutant emissions and higher utility bill costs over the course of their 25-year lifetimes, and postponing the benefits to consumers of emissions reductions, even though these standards are already long overdue. They were finalized in 2016.
There are boilers on the market that would meet the standard today, correct? I mean, the new standard.
Correct.
Would it be possible, just in principle, for the industry to comply with the rule by simply removing some of its existing offerings from the market?
I'm not sure of the answer to that, Your
Keeping
Honor.
on the market those that would be compliant.
I believe the compliance deadline applies to boilers that are manufactured after that particular date. So I don't know that the rule requires them to remove anything from the market.
If they can't meet, if they have some models that cannot meet that standard, they couldn't go on producing them after the deadline, right?
Correct.
Okay.
After the compliance.
So they might, we don't know, but that might mean they just discontinue those models and stay with the ones that do comply.
That do comply, yes. And presumably, again, manufacturers are already making those decisions and may have already made those decisions now.
Well, as I say, they may have decided to do nothing, and then they'll take them off the market if the new rule goes into effect.
Yes, they could.
Okay, let me make sure there's no additional questions for you, Ms. Wu.
No.
Thank you.
Thank you, Your Honor.
We'll hear from petitioners for rebuttal. We'll give you 3 minutes to wrap up, and I don't know which one of you is doing the rebuttal.
This is Barton Day for petitioners again. I'd like to respond to a couple of the issues raised about random assignment because there are some serious red herrings here. The petitioners have not argued that there's some need for complex modeling or anything else. DOE has addressed consumer purchasing behavior in the context of fuel switching analysis in other rulemakings. It's not a big deal, it's simple, and it's something DOE has done. The idea that there needs to be some elaborate model that accounts for every conceivable consideration is simply an effort to make the unnecessarily complicated the enemy of the reasonable. What DOE did in terms of its random assignment approach isn't reasonable. It's not remotely reasonable. It grossly overstates the potential for standards to provide economic benefits for consumers to an extent that I think it's improbable, very improbable, that DOE could justify these standards based on the same record. And if it has to reopen the record, which of course it should, obviously they relied on a huge increase in the price of natural gas to justify these standards, and that didn't occur. So the idea that this random...
I just want to make sure that I'm clear on what you're saying. So your position is that basically the major failure here is we don't know where all this data came from. They haven't taken into account the certain relevant assumptions, but that it's not going to require a whole new rulemaking from scratch necessarily if we were to remand.
No, I'm suggesting they have serious issues they have to address. The context is important here. DOE started out this rulemaking acknowledging that it needed clear and convincing evidence, and then it received comments pointing to all the holes in the record, of which there were many. And its response to that was to say, completely unprompted, because no one raised the issue. It's a completely settled issue. And DOE suddenly blurts out, oh, the standard doesn't apply. And then it announces an interpretation of the standard that focuses on its subjective level of confidence rather than evidence in the record. DOE's response to the fact that it didn't have evidence in the record was to say, we reject DC Circuit precedent saying that we have to have our key evidence in the record so that it can be exposed to refutation during the notice and comment process. I mean, the idea that they needed to have evidence in the record to support their standards was not something DOE accepted in concept. And so they're going to have to look at issues, like natural gas prices, like the use assumptions where, they cobbled together something that resulted in increasing these high benefit spikes that drive the average results that they rely on. So they're going to have to do some work. That's not to say that this process has to be all that lengthy, but there are some specific issues where they do not have the record to address these issues in an appropriate way. And again,
let me make sure.
Core issue that they didn't even consider whether there's a need for standards and whether they would provide any economic benefits at all. That can be addressed by looking at what the factual circumstances and trying to come up with an approach that's reasonable, as it has done in the context where it's looking at the circumstances under which purchasers would move from a gas product to an electric product, for example.
Okay, let me make sure my colleagues don't have additional questions for you in your rebuttal time.
No.
Okay, thank you, counsel. Ms. Weiner, you're opening your mouth a little bit. Okay.
If the court, I misunderstood that I had a little time on rebuttal to talk about disruption, but if the court is ready to,
we can give you a minute to give your rebuttal. I didn't have the direction beforehand about who was taking the rebuttal, but go ahead. Why don't you take a minute?
Appreciate it, Your Honor. And just real quickly, I do think what the government has said, it's not clear what happens on remand here. We do think what happens on remand is the government needs to update their record to, at a minimum, use current evidence, as well as address the concerns raised by my co-counsel. That means that there is inevitable disruption in the industry that will have to take steps to comply with this new rule on remand. And that, to your question, Judge Ginsburg, when a new standard goes into effect, manufacturers have to redesign their products, retest them, and certify them to the new standard. So it is quite an undertaking. Contrast that with the lack of disruption from vacating the standards, particularly if the department were to act quickly on a new rulemaking. While environmental concerns are at issue, there's no exception that says environmental concerns are disruptive. And in those cases, petitioners, including the ones cited by the government, petitioners have agreed that vacating would be disruptive. We don't agree here. We don't think it would be disruptive. In fact, we believe the opposite is the case. Thank you.
Ms. Meyer, let's just make sure I understand that. So if they have a model now that they say is compliant with would be compliant with the proposed standard, they would have to get that officially certified should the standard come into effect.
There are annual certification requirements that happen, and so those would apply to even existing products on the marketplace today.
All right, thank you.
Thank you, counsel. Thank you to all counsel this morning. We'll take this case under submission.
Thank you.
This honorable court is now adjourned until Friday, September 10th at 9:30 a.m.